Where is Mr. Venkatesh? Is he online available?
He's trying to get connected. He's trying to get connected. There's some network problem.
Then if he is not available,
It's my lords, I'm there. My lords, I'm there.
yes, please.
Yes, my lord. My lord, at the outset, let me thank you for accommodating me because of my medical condition. My lords, the first thing that I will submit is that my paper book.
You are appearing for whom?
My lords, I am appearing for Atmartham Trust 40910, listed as item number 19 in volume 11.
Is it say?
In volume 11.
Yes.
A page?
Page 635.
Yes, please.
Yes, my lords. Before I go through the exact written submissions, my lords, let me make some opening statements and then come to the written statements, written submissions. My lords, first thing I would like to say, the word religion in 25, religious practice in 25(2)(a), Hindu religious institutions under 25(2)(b), religious denomination under 26, and matters of religion under 26(2)(b are all indeterminate and probably, my lords, incapable of being defined. The word denomination, for instance, can be traced to the word denominatio in Latin language, fortified by medieval Christendom, which allowed the word denomination to be rooted to a particular denomination within Christian religion. And it was picked up by the Irish Constitution, and we have adopted it. So it has huge foreign roots. And to this extent, my lords, these words have their own limitations in terms of our understanding. Now, what gets compounded is that while 25 to 28 have, while Article 25 to 28 have the roots to Article 44 of the Irish Constitution, 25(2)(a), in the way it is being read, and 25(2)(b), my lords, have no international precedence. In the sense, 25(2)(a) and 25(2)(b) are sui generis and are rooted to Indian conditions and are tailor-made for certain Indian conditions. This requires decisive interpretation and probably intervention of these courts. Moreover, if there is a definition for denominational temples and a certain class of temples falls into denominational temple, my lord, what happens to non-denominational temples? Do they have no rights? Do they have no protection under the Constitution? And how do we deal with non-denominational temples? And the way it has been interpreted, my lord, and I will demonstrate very shortly. The problem is all this becomes a sort of public place, which is equated to a park, railway station, or a bus stand, where anybody can enter and anybody can exit. And then, my lords, it would seem that the Jehovah Witness case, which has been relied heavily in the formulation of 25, originally propounded the wicked doctrine, which is what 25(2)(a), 25(1) is all about. And 25(1) deals only with wicked doctrine, which I would say that, as I think my lord Sundaresh pointed out, even on a mere reading, it should shock the conscience of the court. And that is where my lords, courts have interfered. My lords, then the question I will ask myself is, how free is free? What is practice? What is equally entitled? Freedom of conscience and all persons, which are all related to 25 and 26, which needs probably elaboration and decisive intervention by this court. My lord, a secular state which basically seeks to truncate religious freedom in one way or the other, apart from what is laid out in 25(1), in my humble submission, my lord, goes against the basic structure doctrine. And as beautifully put by the learned SG, it cannot be a case where a secular, on one hand, we say we are a secular state, we will not interfere in the religion, and also say religion should not be interfered in the spheres of secular aspects of the state. My lord, the intersection will be there. Nothing is absolute in this life. But that intersection must be so minimalistic, must be so thin and clearly defined, and arising out of that definition, the rules and regulations will be so clearly enunciated by this court. But for which I would say, my lord, that the whole process of doing this exercise will again result in some sort of a confusion. And then lastly, my lord, I ask myself, the controlling inquiry under 25(2)(a) is whether the intended law is predominantly secular in purpose and whether its application to religious setting is incidental, or is it that it is religious in its character and intervention of secular incidental secular nature, and therefore should it, if the first proposition holds true, should it be absolutely non-invasive of the religious code? My lord, I will start with one small issue that Dr. Ambedkar, I'm sorry, my lord, I think my colleagues will assist you circulate this. This is from volume 7 of Ambedkar's speeches. And
We will ourselves will read. Mr. Venkatesh, you can continue and finish your, because we have given because of special reason half an hour.
Yes, my lord. I'll quickly finish it. Defilement, as observed by the primitive society, was of a temporary duration, which arose during particular times such as the performance of natural functions, eating, drinking, etc., or a natural crisis in the life of the individual such as birth, death, menstruation, etc. This it talks about defilement. After the period of defilement was over and after the purificatory ceremonies were performed, the defilement vanished and the individual became pure and associable. But the impurity of the 50-60 millions of the untouchables of India, quite unlike the impurity arising from birth, death, etc., is permanent. The Hindus who touch them and become polluted, thereby they become pure by undergoing purificatory ceremonies. My lord, the point I'm trying to emphasize here is, Mr. Ambedkar clearly made a point of distinction between untouchability and temporary defilement. And this, I thought, was lost by the Sabarimala judgment, which is a core and arises from the speeches of Ambedkar in 7th volume. Then, my lords, I will quickly go and merge two questions, question number 1 and question number 5, and address this court on these two questions. My lord, as I pointed out, question number 1, what is the scope and ambit of the right of freedom of religion under 25? What is the scope and extent of judicial review with regard to religious practice as referred to in 25? My humble submission, my lord, here on this point would be, when 1 is expansionary, question number 5 will recede to the background or it will become residuary. So if question number 1, if lordship comes to a conclusion that if the scope and ambit of freedom is sky high, my lord, to that extent, intervention becomes to that extent limited. My lord, I will now turn to, as I pointed out, my lord, to what was read in by the learned Solicitor General when he pointed out to Alladi Krishnaswamy's letter to B.N. Rao on April 4th, 1947, and on which, my lord, the Jehovah Witness was clearly quoted, and where the wicked practice, I'm not reading it, my lord, again, because Solicitor General has read it out, but this, my lord, 25(2)(a) of restricting on public order, health and morality is a universal check on practice of religion. 25(1), I don't have any problem. 25(1) is a universal standard. We have given a commitment to the human rights, UNHRC, UN, all these things. We have given a very clear commitment. We will protect freedom of religion, but for these three, which is a universal standard. Then 25.2, my lord. 25.2 is probably the issue that I will tackle now. 2A permits only regulation of secular activities as does not in the effect of operation abridge the core of the religion freedom. Any law which under the guise of regulating activities associated with religion, identifying ERP, essential religious practice, in effect abridges religious freedom and hence in my humble submission would be violative of Article 13.2. My lord, on one hand, we say that 25.2A, if I can bring it out, my lord, that 25.2A contemplates a secular law, intervention into a secular law, where religious practices or issues are in the periphery. I'll give a simple example, my lord. The words are political, economical, financial, and other such laws. My lord, an electoral law, which is primarily political, but it says that you can't use religion in the matter of electoral laws, is very much permissible under 25.2A. But my lord, we have turned the whole argument upside down. We have started reading religious law in association with secular practices, then boxed religious practices into a corner by defining the core or what is called as the essential religious practices, kept the field open for secular practices to be interfered. Let me take another example, my lord, charities. A charity per se should be a secular affair. But a religious charity, my lord, would fall under the ambit of only religion and it should not be interfered. What is happening is we have expanded the scope of religious charity to bring in again within the ambit of charity and then say that this is a secular affair and then started interfering. So, my lord, a judicial policy has to be evolved to say once it enters the religious thicket, a charity per se, say I give money to a person to watch an IPL, it's not coming under 25.2A. But if I say that it is for Godana in a temple or in any other religious place, my humble submission, my lord, that it should be protected and it should come under the protection of 25.2A. My lord, then 25.2B, Learned Solicitor General has taken through Devaru and other judgments. My lord, I will only say here 25.2B has and 25.2B, 25B and 25.2B, my lords. These are two interplays which my lords were, this court is agitated about what is to be done on this. My lord, my humble submission on this is, as far as throwing open to all classes would include every caste and every community within. As far as sections of Hindus, my lord, I regularly go to Sabarimala. In Sabarimala, my lord, typically in Hindu religion, in a yatra, all castes and communities dissolve and it becomes a section by itself. When we go on to Sabarimala pilgrimage, there is nothing called caste there. There is nothing called class there. There is only one thing that sustains. It is the Ayyappa section, which comprises of all sorts of devotees. Section, perhaps, my lords, is used only in the context of Hindus where it is the intermixing of all classes of Hindus. And that should also be a probably mobile one. It moves up and down. It moves, it's vertical, it's horizontal, it's probably even diagonal in the sense we can extend any type of meaning to it. But that would mean that any section of Hindus would be allowed to enter a temple. But when it comes to 26B, my lord, it is only to manage its own affairs. Now, my lord, I'll give a simple example on this. My lord knows several people come to watch the proceedings in Supreme Court. It's thrown open. That is allowed. But then the registrar maintains and actually runs the affairs of the Supreme Court in terms of its administrative side. Anybody who enters the Supreme Court cannot say by virtue of 26B that I will also manage the affairs of the Supreme Court. There are clear distinctions. The denomination is protected from management, from managing its own affairs. Whereas, as far as I am concerned, my lord, everybody must be allowed. Devaru is good law as far as temple entry is concerned. 26B must be allowed so that every distinctive denomination, sections thereof must be allowed to move from one temple to the other. But the larger issue is management. Insofar as denominational temples are concerned, I would make it a humble submission that that must be very clearly restricted. That must lie only with the denomination, and that must be protected. And that protection is non-negotiable, inviolable. Then, my lords, I had dealt extensively in my written submission also on the issue of Sampradaya, which was taken over, which was taken and discussed by the learned ASG. I would not repeat it, but all that I would say that Hindu religion is built up of 6 larger philosophies: the Nyaya, Vaisheka, Sankhya, Yoga, Purva Mimamsa, and Vedanta. It is only the Vedanta which is the 6th philosophy, and each philosophy is traced to a single sage. And these are still documented. There is no question about it. As far as the Vedanta is concerned, my lord, that is where it gets split into Advaita, Dvaita, and Vishishta Advaita, with Lordship knows all the great rishis who have propounded these philosophies. And it is arising out of this philosophy of Vedanta, we have the temple, we have huge amount of rituals, the agamas, the shastras, sampradayas, all this, my lord. And that is why the word all persons in 25, I would humbly submit, my lord, the word person is heavily defined in the Income Tax Act. It includes individuals, it includes AOP, BOI, association of persons, body of individuals, trusts, corporate, non-corporate bodies, partnership. But when it comes to the constitutional issue of persons, I would say Sampradaya is a person. I would make it the Sampradaya, the lineage itself has to be revered as a person. And that is our connectivity to our ancestry. That is our connectivity to our forefathers. And this is what makes this a civilization. This is what was promised when on December 13th, 1946, when Pandit Nehru makes his opening speech on the contours of the constitution, he makes it a point, this is an ancient land. And when it is an ancient land, my lord, I would humbly submit that the entire issue of dealing Sampradaya itself as a person and giving it the protection of 26 is inviolable and non-negotiable. Sampradaya, in the way, if it is understood from what I would say from the Hindi text of the Constitution, it would mean, my lords, that I am here propounding a Sampradaya, and that is where it is unique to my temple. The constitutional framers could not have pitched it so high, the definition could not have been so high, that 95% of the temples in Tamil Nadu out of 40,000 do not fall under the definition of denominational temples and are held to be public temples. And once they are public temples, my lord, they are denuded of the right of even under 26, and then they are treated as public spaces. This, my lord, needs addressal. Unless an expansive definition is given to denomination inclusive of Sampradaya, and all Sampradaya temples must be held to be protected under 26. Lordship may cut off a period of, say, 100 years. Let us say 100 years, or such temples or Sampradaya which have stood the test of time may be a good argument point to pitch in for Sampradaya. Then, my lords, as far as morality is concerned, my lord, I don't want to go. I will go by what the learned SG has said. I will leave it at that. The meaning of the expression sections of the Hindus under 25(2)(b), my lord, I have briefly alluded to it. I would say that the word sect is defined very heavily in Shirur Mat, which is in page 5.1, page number 177, which is a continuous page, and the internal page of 1022. That I'll just read 2 sentences. It is well known that the practice of setting up of maths as centers of theological teaching was started by Sri Shankaracharya and was followed by various teachers since then. After Shankara came a galaxy of religious teachers and philosophers who founded the different sects and subsects of Hindu religion, and we find in India at the present day, each one of these sects or subsects can certainly be called a religious denomination. My lord, in this connection, my lord, I had the privilege of getting a small note from Kanchi Mutt. His Holiness has sent this note to me, which was written by Holy Paramacharya, somewhere during the formation of our constitution. I'll just read it and have it circulated, my lord.
Yes, please.
If such a constitutional guarantee has been got for the independent running of the religious institution, it is no small measure due to the initiative of His Holiness Sri Kanchi Kamakoti Peribal. Originally, the wording was every religious denomination shall have the right, etc. Nobody found any discrepancy in the wordings, including the August constitutional makers. His Holiness alone saw that this was not enough. No Hindu thinks that he is first and foremost a Hindu. He thinks only in terms of subsect. Example, that is a Vaishnavite, a Shaivite, a Smarta, or a Saiva Siddhantin, and so on and so forth. Similarly, no religious institution in India is running under the label of Hinduism. We only have Vaishnava, Shaiva Smarta, Saiva Siddhanta, etc. Mutts and monasteries. So the word religious denomination could not have constitutional application to many of these institutions. Therefore, His Holiness felt that the wording should be changed as every religious denomination or any section thereof shall have the right, etc. His supreme will was ultimately carried out. My lord, I will have this note circulated, but this is sufficient to point out that it had agitated the Kanchi Mahaswami way back in 1948, that he had sent a note to the constitution makers, and that's how 26 had undergone certain changes. Then, my lord, I will draw attention to Rule 6 of the Kerala, Travancore Cochin temple entry rules, which is very important and very, very instructive in the context of Sabarimala. The Rule 6 says the classes of person mentioned hereunder shall not enter within the compound wall of temple or its premises in case there is no compound wall. A, persons who are not Hindus. Persons under pollution arising out of birth or death in their families. C, women at such times during which they are not by custom and usage allowed to enter temples. D, drunken or disorderly persons. E, persons suffering from any loathsome or contagious disease. F, persons of unsound mind except when taken for worship under proper control and sanction of chief officer of the Devasam concerned. And G, professional beggars. My lord, I will pause here and make a very important submission. My lord, this is not regarding Sabarimala. This is regarding all temples in South India, primarily. Women, when they undergo a monthly biological process, voluntarily, by their own discipline, they don't enter temples. This is a non-written rule that even in the house, they don't enter the puja room. Now, this is my belief, my lord. I can't give a scientific explanation. But when science ends, belief begins. And belief ends when science begins. My lord, this is constitutionally protected by the word belief. And this is practiced as a discipline by all ladies or most ladies in South. I'm sorry, my lord, I'm not saying North doesn't practice it. I'm not aware about it. That I must profess my ignorance on this. But mostly, that in across all communities, across all castes, this is a standard practice. And then, my lord, whether person belonging to a religious denomination or religious group can question a practice that a religious denomination or religious group by filing a last question, my lord. I would go by other seniors' submissions on this. I'm not going to elaborate. But, my lord, I will just close with 2 minutes, my lords. My lords, there is a wonderful document called Endurance of National Constitutions by 3 scholars, Zachary Elkins, Tom Ginsberg, and James Melton of Cambridge University Press 2009. My lord, in this, they take a study of the endurance of constitution. How long has the constitution endured? And as a part of this project, they have taken all constitutions, written constitutions beginning 1776, my lord, and till around the beginning of the 21st century, around 225 years. In that, they quote an exchange between Madison and Thomas Jefferson. And Thomas Jefferson is famously said, the dead should not govern the living. And Jefferson went on to suggest that there must be a 19-year figure for every constitution as per his own actuarial calculation to end. And these scholars also made a finding that most of the constitutions come to an end within 19 years. But my lord, I'm not making that point. I'm only making the point that we are in a judicial policy. Article 25 and 26 will be subject to several interpretations as the time flies by. I would only submit, if this August bench also leaves a note to the future bench 25 years down the line, that to continue with this review until for that 25 years, whatever you say, my lord, will be binding on this. I would again thank my lord and apologize to my other seniors for having jumped the queue. Thank you, my lords. Much obliged.
Thank you, Mr. Venkat. Thank you very much. Yes, Mr. Kumar.
Mayor, please, my lords. My lords, there is
Whatever you have.
just pass on the arguing note to whoever it is. Rakesh Kabir.
Yes.
My lord, there is an arguing note before your lordships, my lord, which I will refer to. I will not refer to my long written submission at all. Cross references are here. There is also a small compilation of a case and one quotation from P.N. Saraswati, which I will place before your lordships. My lord, let me begin at the outset, my lord. On April the 7th, my lord, the Chief Justice, put a framework, my lord, on discretion and how high or how low one could go on this. He said it could be a broad discretion, my lord. Your lordship then it could be no discretion. Then your lordship said it could be a narrow discretion, but to insulate minorities. And fourthly, my lord, your lordship would indicate it could be case by case. It's going to be our submission, my lord. It should not be case by case because certain principles have to be laid down. Now, my lord, a lot of questions fell from your lordships, my lord. A large number from her ladyship, Justice Nagaratna, my lord, on the question of whether essential practices is in fact a juristic invention. When we look at existing law, does it include custom? And a range of others, my lord, which are of crucial importance. My Lord Justice Amanullah asked a very important question relating to whether when you have a superstitious belief which has an external manifestation, then can we say that the external manifestation is not subject to judicial review? There were important questions that fell from my Lord Justice Sundaresh and Justice Kumar, my lord, which were very, very important about judicial intervention. And of course, the question from my Lord Justice Sundaresh we have to answer, that does logic apply to a belief? A very important question which we have to answer. My Lord Justice Varale asked an important question, my lord, to Mr. Singhvi, when he said you can go to any Ayappa temple. Now, if it is a question of choice, my lord, and there is one temple which has significance, then obviously, my lord, it's not a question of going from one to the other. A range of questions fell from my Lord Justice Bagchi, my lord, and they are extremely important. One of the important questions is whether Article 26 is a subset of Article 25 and just a conglomeration of individuals who have come together. Now, my lord, that's extremely important, my lord. I have one indulgence to ask your lordships, my lord. I'm wearing a hearing aid. If it squeaks, your lordship should, my lord, ignore the squeak. Like Mr. Abhishek Singhvi, when the orderlies came and he said, I'm seeing 18 people, my lord. Because of a corrective prism in my specs, if I turn my head, my lord, I'll see 18 of your lordships, my lord, which is more intimidating than what I see right now. Now, my lord, let me start on this note, my lord. Your lordship is not, my lord, just protecting Hindu practices. Your lordship's concern is to lay down the law for everybody. Every belief, every matter of conscience, every, my Lord Justice Nagaratna, my lord, raised a very, very important question as a preface in Article 25(1), which I will come to. Now, my lord, kindly come to 5 points that I want to raise in advance. My lord, I wanted to raise this because foundational questions I'm concerned with, my lord. Now, my lord, my first question is that the Indian Constitution was designed for a civilization state. That is, my lord, on page, the first page. If you take, my lord, all of Europe, all of sub-Saharan Africa, all of Russia, part of, my lord, Southeast Asia, and you take all of the Americas, my lord, we will have a diversity far greater than all of them put together. This is why I say, my lord, and it's a phrase of the scholar, Professor Ravinder Kumar, it's a constitution not for a nation, but a civilization state. And I would add to that a multi-civilization state. And that is, my lord, of crucial importance that guided the 11-judge bench in TMA Pi. So if your lordship will permit me, I will read from the next paragraph. It's of crucial importance, my lord, because this is a perspective, my lord. It's not about one temple or the other, one belief or the other, my lord. It runs across the board. So, my lord, if your lordship will come to 1.2, this is, my lord, a guiding principle we get in TMA Pi. The 1 billion population of India, contrast, consists of 6 main ethnic groups, 52 major tribes, 6 major religions, 6,400 castes and subcastes, 18 major languages, 1,600 minor languages, and dialects. The essence of secularism in India can best be depicted if a relief map of India is made in mosaic, where the aforesaid 1 billion people are the small pieces of marble that go into the making of a map. Each person, whatever his, her language, caste, religion, has his, her individual identity, which has to be preserved, so that when pieced together, it goes to form a depiction within the different geographical features of India. The small pieces of marble in the form of human beings, which may individually be dissimilar to each other, when placed together in a systematic manner, produce the beautiful map of India. Each piece, like a citizen of India, plays an important part in the making of the whole. The variations of the colors, as well as the different shades of the same color in a map, are the result of these small pieces of different shades and colors. But even when the small piece of marble is removed, the whole map of India would be scarred, and the beauty of it. Each of the people in India has an important place in the formation of the nation. Each piece has to retain its color. By itself, it may be an insignificant stone, but when placed in a proper manner, goes into the making of a full picture of India in all its different colors and hues. A citizen of India stands in a similar position. The Constitution recognizes the differences amongst the people of India, but it gives equal importance to each of them, their differences notwithstanding, for only then can there be a unified secular nation. Recognizing the need for preservation and retention of the different pieces that go into the making of a whole nation, the Constitution, while maintaining inter alia the basic principle of equality, contains adequate provisions that ensure the preservation of these different pieces. The essence of secularism in India is the recognition and preservation of types of people with diverse languages, different beliefs, and placing them together to form a whole of united India. Article 2930, and your lordship may substitute 25 number 6. I come, my lord, now for the second part of the template that I'm placing before your lordships, and that is on page 3. The extent of religious faiths in India, my lord. I will rely on a quotation, my lord. Sometimes what we do, that's true of Constituent Assembly debates, we pick out, my lord, one particular comment, and we forget what the ratio is, my lord. But it is a statement of your lordship, so let me proceed. In SP Mittal, my lord, your lordship is aware of the case. Quite obvious, my lord, I'll go only to the underlined portion. There may be, and indeed there are in this vast country, several religions, less known or even unknown, except in the remote corners or in the small pockets of the land where they may be practiced. A religion may not be widespread. It may have little following. It may not even have a name, or indeed most tribal religions do not have. We may only describe them by adding the suffix ism in the name of the founder teacher. Let me stop here, my lord. What your lordships will decide will affect tribal religions too. It's important, my lord, because there is, say, often, my lord, we say social reform provisions should apply there or should not apply there. The manifestation of external superstition, should it apply there, should it not apply there? The example the solicitor took of witchcraft, should it apply? I worked with an NGO, my lord, in Jharkhand, where the concept of then a witch, my lord, and there was a legislation, or they tried to pass a legislation concerning that. What do we do about that, my lord? It's not decided on Hindu law principles, my lord. Next, my lord, I come to a very important statement made by Justice Dwivedi in Keshwanand. I'll read it. The Constitution is not in a state of being, but becoming. This is a very pregnant statement. Mr. Venkatesh also, my lord, made the statement just now that you go into how many years and how many years, but you change all the time. And therefore I say, fates evolve and change over time. That change, my lord, does not come, my lord, by statute alone. It comes from people. An example was given, my lord, of a woman becoming the Archbishop of Canterbury. I debated against Archbishop Ramsey, my lord, head of the church. I asked him, I said, why are there not women priests? His reply was, I have to carry my flock with me. And it's important, a leadership role. So we can go about, my lord, doing social reform after social reform. If it has no meaning, my lord, in the where it counts with people, my lord, somewhere or the other, we might be missing the wood for the trees. My third, my lord, next is the secular framework of India. My lord, the following were rejected by the Constituent Assembly. In the name of God, then again in the name of God, in the name of God Almighty, Mahatma Gandhi, by the grace of Parmeshwar, the Supreme Lord of the universe. Now, my lord, all this was rejected. We have a secular constitution, my lord, and even in the objectives resolution, because Pakistan was around the corner, they said, look, let us hold this preamble, and the preamble was decided, my lord, at the end in 1949. Now, my lord, on change, I want to add something. My lord, there is a Hindu concept, it's sometimes, my lord, attributed to Parashar, wrongly to Manu. Anye kriti uge dharma tretayam dwapare pare, anye kali uge niram yugurupa nusarita. So yugurupa nusarita, some people say it's by epoch. Certain, my lord, very great Dharma Shastris like K.P. Jaiswal, my lord of Bihar, who wrote this wonderful book, Manu and Yagyavalk, my lord. He says, no, it is not epoch. It is time. We go from one time to another time. We evolve, sometimes slowly, sometimes fast. And therefore, my lord, we have this secular constitution. And the last thing, my lord, which fell from your lordships, is my fifth template, which is on page 4. My lord, after partition, the Constitution was a solemn promise to heal a diverse nation. Healing part of the Constitution for everybody. This is, my lord, captured by Justice Khanna. It's in my, forget it, my lord, it's in my larger thing. Although in the context of partition, this has relevance. After the emergency, it was used to fight tyranny. Today, we live under intimations of divisive forces where healing is crucial. And it's a question that fell from your lordships, my lord. If this happens, will we divide society? If this litigation comes, will we be dividing or will we be harmonizing? I have a take on harmonizing, my lord. I'll come to that. And that, my lord, in your hands, the healing process, my lord, is very much part of the interpretation of Article 25 and 26. Now, my lord, I must say that a a foundation has been laid, my lord, certainly by the solicitor when he played all the cases before your lordships, my lord. Mr. Vaidyanathan's, my lord, analysis. And I'm going only by the analytical propositions. I'm not getting into Sabarimala or review or whatever. And certainly, my lord, by Mr. Singhvi. And this is important. Now, let me give your lordships an anecdote. My lord, I spend 1 hour every day with my staff. I say, ask me any legal question and I'll explain it to you. Now, this morning, my cook and Major Domo asked me, "Abhi tak kya bahas hui hai?" So I said to him, this. So he said, "So aap kya bahas karenge? What will you argue?" So I said, "Baat aisi hai. दाल को उबाल लो, उसमें नमक डाल दो, उसके बाद छोका होगा, तो गरम मसाला मैं ऐड करूं." So this, my lord, is an argument for garam masala, my lord. Just tweaking, my lord, nothing more. I now come to a question, my lord, that was raised by Her Ladyship Justice Nagaratna about what is the connection with Sabarimala. What really is the connection that brings out these? Now, my lord, I briefly, my lord, explained this. I will read it out very fast. What happened, my lord, is Justice Khanwalekar, who was with the majority because he had subscribed to the judgment of the Chief Justice Mishra, changed his mind. Justice Gogoi replaced Chief Justice Mishra. And of course, Indu Malhotra then becomes a majority, which is responsible, my lord, for this reference. Now, my lord, may I come to para 2 of 2.1? Just to explain, my lord, it's important. What are the issues we are discussing in the wider concept of the perspectives that I had indicated? In the earlier judgment, while Justice Mishra, Khanwalekar and Chandrachud were of the view that the exclusion of women from pair was not an essential practice, Justice Nariman proceeded on the basis it was an essential practice, and thus concurring with Justice Malhotra. Next, on the meaning of morality in 25(6), while Justice Mishra, Khanwalekar and Chandrachud were of the view that morality meant constitutional morality based on liberal egalitarianism, Justice Nariman felt that it was something abhorrent to a civil society and rejected the idea of constitutional morality. Then, my lord, Justice Malhotra took a different view of constitutional morality to reinforce pluralism, secularism, and religious diversity. So, my lord, here we have a difference of opinion, my lord. And that same difference of opinion divides us, my lord, may divide your lordships, my lord. For that, we will have to see. The next, my lord, Justice Chandrachud insisted that other provisions of Part 2 must go to 26, and which did not contain such a phrase. Justice Nariman took the view, you decide this on a case-by-case basis. Then over a crucial question related to whether the Ayyappan practice in this case was a denomination. This is an important point. I mentioned it, my lord, when we started. If something is not a denomination, it loses the right of 26. Therefore, my lord, the Ayyappans lost the right of 26. And I will explain to your lordships in my own humble way, my lord, what 26 actually implies. It is the most important article, my lord, in this configuration of 25 and 26. The next, my lord, Justice Chandrachud took the view that excluding women was a form of untouchability under Article 17. This was not accepted by Justice Malhotra. A seemingly new test of essential practices was formed whether denying a practice constitutional recognition will be unless it altered the faith of the person. Now, my lord, this is a very narrow test, too narrow, because effectively it says, show me how it will change your faith. And if it will change your faith, then it's an essential practice. This is much too narrow, my lord, because it's a very narrow test. It's like the test that says your core beliefs will be protected, nothing else will be protected. Then, my lord, Justice Chandrachud took the view that proportionality to test invasiveness would obviate examination of tenets. So he said, let's just go straight away to proportionality. Let's forget everything else. Why are we going into all these religious questions? This was not accepted by the judges who concentrated on essential practices. Justice Nariman referred to Justice Iyengar's consideration, are you swallowing up all the religions? And then, my lord, what he says in the last sentence, he felt that he says that this view could be tested in some other future case. This question of, in our interpretation of 25 and 25(2)(b) and 26, are we in some senses or not, my lord, swallowing up the religion completely? He accepted the argument in one sense, had an interpretation, and he said, no, this is to be decided in a future case. Your lordships is that future case, in my respectful view. And finally, my lord, I am not like Dr. Singhvi, to some extent, Mr. Vaidyanathan or Mr. Mehta, going into the merits of Sabarimala bill. That's not before your lordships. Now, my lord, the entire discussion for the last 4 days has been decoding Article 2526. That's the entire discussion. And therefore, my lord, that is important. I believe 27 is important and 27, 28, but I'll come to that later. May I just take the Constitution, and that will, my lord, relieve me from excessive reading. I'm not a very confident person. Now, my lord, I come to 25(1). Forget about the limitation for the moment, my lord. It mentions all persons are equally entitled to freedom of conscience and the right freely. Her Ladyship Justice Nagaratna emphasized the word freely. It's a very important phrase, my lord. I will say, my lord, that when we say freedom of conscience, we are raising a very, very big issue, my lord. I have the freedom of conscience to challenge anything. I can challenge the state. I can go to a religion, and very respectfully, because the question of hate speech has now been looked at in Kaushal Kishore. Your lordships have put on both sides with nuances. I don't want to go into that. Respectfully, my lord, this right of conscience, freedom of conscience, is a very, very expansive right. It is a right given to all of us to question anything, but respectfully and in a bona fide manner. Now, my lord, I come to freely. A person belongs to a particular faith. He's a dissident. He says, I belong to the faith, but I have my own difficulties. And of course, Hinduism, my lord, shows how there is, my lord, such a plethora of people who freely take a distance from the main religion. This happens all the time, my lord. It will happen to the conscientious objector. And they will say, my lord, at the end of the term, freely means my right to follow the religion, not follow the religion, to tell the religion something is wrong with your religion, to say that in most respectfully, because Kaushal Kishore has defined the parameters, my lord, of hate speech. We cannot have hate speech in this society. Simple. Absolutely simple, my lord. And therefore, that issue, my lord, goes against. Therefore, I say bona fide, my lord, is important, and respectfully is important. So, my lord, these two are fundamental to the transformation of religion as well. Today we celebrate, my lord, Jyotibai Phule and Savitribai Ben. What is it about, my lord? They sought to reform, like Justice, Baba Sahib Ambedkar. He went to Mahad. He said, look, I am going, whether you like it or not, I am going to bathe here. The law didn't change straight away, but it was important. So it is this tension, this dialectic that exists between people who freely exercise their right and who exercise their conscience rights. This, my lord, your lordship will bear in mind, it is of crucial importance. Now, my lord, I will come to the...
Are you saying that conscience is something larger than religion?
No, my lord, conscience I go by
The
what,
word conscience should take the color from the word religion itself. Is it coterminous?
it could, my lord, it could not. And I go by Justice Amanullah's, that conscience sometimes externally comes, my lord, as a manifestation. I want to separate the manifestation from the conscience, but my lord, it exists in all of us, and freely it relates to the religion.
Yes.
That is, my lord, the question that your ladyship put, and I'm seeking to answer it by this interpretation. Now, this is of considerable importance, but my lord, let's just get back to one other part, subject to the provisions of this part. My lord, your lordship normally classifies fundamental rights as, apart from the state, etc., as liberal egalitarian rights, which go from 14 to 18. Then, well, actually 14 to 22, because all the rights are involved there. Then there's the anti-exploitation rights, 23, 24. Then the cultural rights, my lord, and the religious rights, which are clubbed together. This is the normal thing. I would like to go, my lord, for one thing that certain articles of the Constitution tell us. Now, my lord, take the article of untouchability in Article 17. This is, my lord, stands on a separate footing of its own. In other words, no court, no religion can ever flout the diktat of Article 17. It doesn't matter, my lord. If there is somebody who manages the affairs of religion, this diktat has to be observed, period. I do the same for equality, 14, because it says equality of persons, and etc., etc. Now, that is a universal diktat. 23 and 24 are universal diktats. And therefore, my lord, they stand on a different footing. We don't have to go, my lord, to the doctrine of constitutional limitations to say, is this a limitation in 26? We don't have to go there. These, my lord, are constitutional statements, juristic statements, which fly over everything else. Bear that in mind. Otherwise, my lord, we'll ask, why was this omitted from 26? Why was this not somewhere else? We don't have to go there, my lord. For certain statements that are of universal application, they will apply across the board. That's, my lord, an interpretation. My lord, my mother used to tell me that when we go and buy sarees, you throw one saree, then you throw another one, another third one. Now, whether they will like it or not, we don't know. But at the end of the day, my lord, we are saree throwers, my lord, and your lordship will no doubt decide all this, my lord, to the best of your lordship's ability. I come now, my lord, to 25, 2.
Mr. Dhawan, just an interjection. You said that freedom of conscience has a very wide amplification.
Yes.
I'm just throwing a proposition. Probably I would like assistance. Are you hinting that as judges, as a constitutional court, religion and conscience cannot be equated for the reason that religion may be very personal to me, but then when I have to judge, I have to rise above that religious consciousness to a level where I balance it with the constitutional provisions and then see the larger picture coming out, emerging from that. So probably we'll have to rise above. But say everything is being focused that when it is religion, don't touch. Probably as constitutional authorities and in the scheme of the constitution, we are called upon to get into the area of conscience also. And that may probably not be restricted by the term religion. Is that could be a proposition?
Lord, I respond to that, my lord. I've never had the privilege of being a judge, my lord, but your lordship has a persona as a judge, my lord, which goes across the Constitution. Your lordship doesn't have to exercise your lordship's conscience on this. Your lordship just has to interpret the concept of conscience. And therefore, my lord, there was a very nasty article written by an English professor. Why did a Mohammedan judge decide a Hindu question and a Hindu decide a Mohammedan question? My lord, when your lordships are judges, your lordship has a persona of your own. The reason why I was mentioning this, my lord, freedom of conscience is mentioned separately from freely religion. Therefore, there are two rights there. And they're two very vital rights, my lord. They're not just vital, just me saying, my lord, that, look, I have this conscience, I can do whatever I like. The court has to be bona fide. You have do it respectfully, under caution Kishore, etc., etc. These are two separate rights we have. Your lordship's conscience is your lordship's own, my lord. I can't say what your lordship will take into account, but your lordship
Would it be your proposition? Would it be your proposition that we have to rise above that limited scope, that whether it should be just religion and leave aside, that should not be the approach?
No, my lord. No, my lord. Freedom of conscience is separate from religion, my lord. There are two rights that are there. They are separate rights. Freedom of conscience is a separate right. And, my lord, the religious right and fairly is a separate right. Your lordship will have to interpret it, my lord. Now, my lord, I come to two. I'm sorry, my lord, your lordship.
So you are right, entitled to freedom of conscience and then right to freely to profess, practice and propaganda. Actually, if you see, it is only from the freedom of conscience emanates the right freely to profess, practice and propagate.
That is correct.
Conscience has to be formed.
My lord,
Then you make your own choice, and then that freedom will come to profess, practice, then come.
Your lordship is right, my lord. As my learned yes, that's right.
Then.
Certainly, my lord. And I can't separate them. There are interconnections in our mind, my lord. In our mind. Now, my lord, I come to an important interpretation of 25.2, my lord. And I am indebted to Mr. Shankar Narayan for this interpretation. Now, my lord, kindly have a look at nothing in this article shall affect the operation of any existing law. Your ladyship put the question, does existing law include custom? The answer is it does. It has to. Because the next part, my lord, is or prevent the state from making any law. So existing law must be a custom. It will apply to tribals, it will apply to Hindus, it will apply, my lord, to Muslims. A very interesting, my lord, study has been done that there are castes amongst Muslims also, my lord. It's very, Professor Imtiaz Ahmad has done 4 volumes on this, my lord. It's very important. Now, my lord, I come to, and to the interpretation. Now, my lord, what does this nothing in this article mean? I had the privilege of discussing it with Mr. Shankar Narayan. Nothing in this article means everything.
Pardon?
It means everything. And I'll tell your lordship why in a moment. My lord, it means that your individual rights cannot stand in the way of social reform and regulation. You can't come up and say, under Article 25(1), I have this right, and this reform is not acceptable to me. Otherwise, the entire provision of 25(2) would be negated. But there is another part also. Why was all this business of other provisions of this part not included here? For the same reason. You can't come and say, when there is regulation or when there is social reform, you can't come and say, my lord, at the end of the day, that, look, I'm not interested in the social reform. I want to go back to part 2, part 3. I want to go to equality. I want to go to untouchability. I want to go to my right of speech. Therefore, my lord, for both reasons, nothing in this article means 2 things. If regulation is going to go forward, if social reform is going to go forward, an individual under Article 25 will not be able to come up and say, this social reform is not acceptable to me. I am relying on the other provisions of Part 3. My lord, sometimes we have discussions in the corridor. This was a corridor discussion, my lord, and I'm very grateful for it. And that is the reason why this phrase, other provisions of Part 3, has to be explained. Because 25(2) will be entirely negated, my lord, if individual rights and other parts come in. That is why it says nothing in this article. Now, my lord, I come to regulating or restricting any economic, financial, political, or other secular activity. Mr. Venkatesh, who spoke just now, my lord, was absolutely right about secular activity. Your lordships, my lord, have been, my lord, asking questions which, to my mind, result in two versions of secular activity. One version is a very simple one, which is secular activity means everything that applies to all of us. If I go to a bank, my lord, I'll have to do banking. If it is to be taxed. And the same applies, my lord, to religious denominations also. He made a very nice distinction, my lord, between religion and charitable institutions. Very important distinction. If you open a charitable institution, doesn't matter if you're Saint Teresa, my lord, you will have to comply with all the secular laws of the land, which are applicable to anybody else. So secular there has one meaning. That's one meaning. Secular means secular activity in its own right. By way of judicial determination, your lordship may well say this has nothing to do with secular. That's a different matter altogether. The other question, and many questions fell there from my Lord Justice Bagchi as well. Secularism means something that is not religious. I am, my lord, suggesting to your lordships that the second proposition is a difficult proposition for anybody. You can't just go around and say, look, this secular is opposed to religion, and therefore your lordships will work it out. I think Devaru, my lord, made a mistake in my respectful submission when it said that there are two provisions of equal authority, and Devaru then said, we will make 26 subject to 25(2)(b). My lord, I don't think. Now we come, my lord, to social reform. Providing for social reform, I'll take that as a composite, my lord. Social reform, my lord, has a meaning. It has a secular meaning, it has an institutional meaning, and therefore, my lord, when we say all this, that the answer, my lord, must, at the end of the day, be, is this connected to social reform or is this a hoax? This often comes up before your lordships, my lord. It has come up in many, many cases, my lord, before your lordships. Is this really social reform? Now, a person would be entitled to say whether it's connected with religion or not. I'm not going into that. But this is not social reform. Your lordship will have to interpret it. Therefore, my lord, I'm giving an integrity to Article 25(2), which is the most important part of Article 25. My lord, I won't take your lordships to the debates because Mr. Mehta has done so, Mr. Vaidyanathan has done so. Because, my lord, it's not just the women members, of course, Hansa Mehta and Rajkumari Amrit Kaur, certainly, my lord, that did say that, look, practice must be changed. This must be changed. What are we going to do about sati? What are we going to do about child marriage? So, this was supported by Aladi Krishnaswamy Iyer in his famous letter of 4th April. And it's important, my lord, because 25(2) will be negated. It will be of no consequence if we either connect it, my lord, to 25(1), and then it will be nullified. Individuals keep saying this is all nonsense, I have my individual right, or connect it to 26. So, my lord, one more interpretation here, and that is classes and sections. My lord, your ladyship mentioned, my lord, the mention of classes in Article 16, Lord. My lord, the majority judgment of my Lord Justice Jeevan Reddy that's the first time I was intimidated by a 9-judge bench, my lord. Absolutely terrified. But he then said classes is not in the Marxian sense. So let's eliminate that for a moment, my lord. It is not in the caste sense either. Classes, my lord, have a very broad meaning of social group. And sections, my lord, follow from that. Therefore, my lord, when we talk of classes or sections, it means, my lord, any social group, any classification which could be justified under Article 40. If women are that group, my lord, then they certainly have that right. That would be my interpretation, subject to your lordship's pleasure. Now I come to 26. The most important article. My lord, Article 26 concerns institutional rights. Can you imagine a religion without institutional rights, without property rights? Can you imagine that, my lord? It's difficult to imagine, my lord. Therefore, institutional rights are the core of Article 26. Without this right, no religion will survive beyond 6 months. It will be reduced to ritual. Now, my lord, this is where I want to go to my compilation, if I may. I forgot to put it there. So let me go there, my lord. No, where the hell is it? Just give me a moment. My lord, first kindly come to page, my lord.
8.16.
My lord, this is a page, my lord. This is a separate compilation that I've given of two things that are not, my lord, on your lordship's record. We're uploading them. Right. For a moment. My lord, kindly come to page 65. Page. My lord, I come from a dissident Arya Samaji background. There were no temples in the Vedas. None. Kindly bear that in mind, my lord. Now, my lord, I'll read on page 65. It's a glorious account, my lord, of what was in the Vedas. This is actually from a forthcoming book, my lord, but P.N. Saraswati is being quoted, not me, my lord. Solicitor was absolutely right. You can't quote yourself in a court of law. Now, my lord, P.N. Saraswati's famous Tagore lectures emphasized the religion of the Vedas was different from the present ones. His lyrical description of famous Vedic gods is alluring. He declared that the religion of the Vedas differs very widely from the popular religion of the Hindus. He describes how the songs of the Vedas were addressed, amongst other things, to Agni, the god of fire, who was a messenger from the men to the gods, however afar. Indra was the mighty god, lord of the thunderbolt, as the thunderbolts of real life made a deep impression on his worshippers. The break of dawn brought its own tranquility, and the sun god provided succor and support. Apart from that, there were others, Maruts, or winds, Rudra, the terrible howling god of the tempests. Sorry, you were asking. In fact, there was in substance only 3 gods in the Vedas: Agni on the earth, Vayu or Indra on the sky, Surya in heaven, of each of whom there are many appellations. I'm sorry, was there a question?
You're not getting your.
Oh, dearie me. My lord, page 65 of this compilation. I'm sorry, my lord, Justice Bhakti has it. Justice Raleigh. I'm very, very sorry. I'll summarize what I've read so far. Your lordship has heard it. There were none, my lord. There were gods. There were 33 of them eventually, because they worship nature, my lord. A pond, they worship there. I go around my colony, people worship trees there, my lord. They should. That comes from the Vedas, my lord. And I go there and respectfully put some money there. I don't know who takes it, my lord, but that's another matter altogether, my lord. So who is Rudra? He's the howling god of the tempests, my lord. How can you run away from that? Yeah, I'm sorry, my lord Justice Bagchi doesn't have it.
It's okay, please.
Just hand over another one.
Is
there another one? My lord, can I hand one over, my lord? Your lordship best. My lord, I was just describing in the Vedas. I've done half a page, my lord. Your lordship has heard it, so I won't. Now, my lord, halfway down the page, the number of Vedic gods is 33, increased multifolds in more degenerate times. Moreover, the names of Shiva, Mahadev, Durga, Kali, Ram, Krishna never occurs, so far as we are aware. We have Rudra, who in his after times is identified with Shiva, who even in the Puranas is of very doubtful origin and identification. Whilst in the Vedas he is described as the father of the winds, and evidently a form of either Agni or Indra. Typically, the Vedics also worship trees, wells, rivers, and the like, to which they were close, and on which their sustenance depended. A distinguished scholar, this is my lord, Justice Mukherjee, my lord, who wrote the Tagore Law Lectures on religious endowments, The religion of the Vedas knows no idol. The worship of idols is a secondary formation, a later degradation of the more primitive worship of ideal gods. Perhaps temples came in the Sutra period. It has been suggested that image worship may have been a direct result of Buddhism. It is difficult to say when idol worship amongst Hindus began. From the Upanishads may have come the idea of a supreme being, and the trinity of Brahma, Vishnu, and Shiva could be seen as diverse and a simple entity, as has been suggested. The gods to whom the hymns of the Rig Veda are addressed as ideal beings who represent the beneficent radius powers of nature, sun, air, earth, sky, dawn. But the Vedic seers had from the beginning a glimpse of the infinity behind these elemental forces, as shown by the conception of Aditi, the mother of the gods, which, as Max Muller says, was the earliest name invented to express the infinite. And from Buddhism, my lord, came the idea which later on becomes Marx. My lord, I'm mentioning this, my lord. In my life, my lord, there was a havan every day in our house. Certainly my grandmother insisted on it, my lord. And we joyfully, my lord, went there. I go to temples, my lord. I pray not for myself, other people. Certainly I do, my lord. But when your lordship sees the expanse of Hinduism, it's not just Charvak that we are talking about. Dayanand Saraswati created the Arya Samaj. His book was rightly banned, Satyarit Prakash. And it was banned because he was vituperative about Christians and Muslims. So in 1926, they banned the book, correctly so. And under Kaushal Kishore, it would have been banned as well. There's no doubt about it. Now, my lord, this is the huge, my lord, diversity of Hinduism that your lordship has to take into account. And this diversity is important. I'm only mentioning this, my lord, personal experience. Now, my lord, the second part of this is the doctrine of Isht and Purtha. This is relevant, my lord, for interpreting Article 26A. Religious and charitable institutions. Hinduism, my lord, places a premium on charity. And there's a number of cases of your lordships. Have you done Isht or Purtha? And there's unfortunately a 1999 case that says, even if you have done it, go ahead, we'll recognize you. This comes from Hindu law. So that's important, my lord. Charity is a part, my lord, of Islam. The concept of waqf is endemic to Islam. And therefore, my lord, when we look at religious and charitable institutions, we might, as was suggested this morning, we might have to separate them slightly, because they may have different regulations attached to them. Kindly bear this in mind. My lord, I've digressed. I come back to 26. My lord, without Article 26 as an institutional protection, no religion can survive. The Vedas survived, my lord, because of rituals and because Mimamsa came, and Mimamsa is a doctrine, my lord, actually to interpret rituals much later. We use it, of course, now for also interpreting law and Hindu law. Now, my lord, what will we do without 26? All religions, my lord, will be doomed to ritual. That is why, my lord, 26 is the most important right for the sustenance of religions across time. Take the institutional practices away. I've given an example here. My lord, we all love the Nazarene Jesus. The Nazarene Jesus' Sermon on the Mount used to say, treat your brother as your own. And I subscribe to it. But then St. Paul came along and told the Greeks, using Greek eschatology and Jewish interpretation, he said, the unknown God is your God. So we got the church. Would there have been a Christianity, my lord, without the church? Wouldn't have happened. It is the church, my lord, as an institution that, my lord, is responsible for the continuance of Christianity. This is true, my lord, of many things in Islam, and it is certainly true of Hinduism. And this 26, my lord, does not cover just Hindu faith. It covers all institutions across the board, and that is why it is so crucial. Now, my lord, I come to the next part. This is the Constitution. Lord, I am, my lord, only on interpretation and foundational questions. Kindly bear that in mind. So, my lord, the next part is denomination. I will deal with it separately, my lord, because it requires separate treatment. My lord, what happened is that this was taken, my lord, not just from the Irish constitution. I have not cross-referred it, my lord. Kindly note the cross-reference, the quotation from B. Rao is in my submission, page 21, 4.3. I will read it out, my lord. I'll just read it out, my lord. Your lordship need not refer to anything. Select documents, he says, that Article 25 and 26 was adapted from the Irish Constitution. Explanation 2 was on the recommendations of the All Parties Conference.
Where are you reading?
No, I'm cross-referring to my submission, my lord. I'm not reading from it, but because I have not included it, I'm just explaining it to your lordship. I'll put it in a jiffy.
Yes.
It was taken from the Irish Constitution. It was taken from the Yugoslav Constitution as well. And it was taken from the Swiss Constitution and the All Parties Conference. So many things went. And as Baba Sahib Ambedkar said, when we borrow, there's nothing wrong, as long as you borrow discerningly and adapt discerningly. Now, the problem is the Irish, my lord, when it became a Catholic state, the state of Era, I don't know, the solicitor had a different interpretation, my lord. I claim to be an Irishman, my lord. I convinced Justice Kapadia. I was citing an Irish precedent and I said, I'm an Irishman, how can you say this? So I told him a story and I said, most Irish people claim to be Irish by descent. My grandfather was Irish, my great-grandfather was Irish. I said, my daughter is half Irish. I'm an Irishman by ascent. I exercise all the rights of an Irishman here, my lord. Now, my lord, we come to this question. They wanted to give all the dissident faiths, the Protestant faiths, they wanted to recognize them. So they said denomination or sect. It actually meant the dissident faiths. And we copied it. And there was no discussion about this. And therefore, my lord, we didn't discerningly, my lord, adopt this here. But it is of fundamental importance, my lord. So let me come back here. 26 shall have the right. Now, this is an institutional right. And I'll show that from A, B, C, D. A is to establish and maintain institutions for religious and charitable purposes. Existing institutions and creating institutions. That's the first part, my lord. Charitable, I have already explained. The second, to manage its own affairs in matters of religion.
Just a minute. Charitable, are you equating gifts and offerings also as charity?
No, my lord, charitable institutions.
A different connotation than gifts and pure offerings. Offering maybe.
My lord, what I'm trying to say, my lord, is this. Religious institutions, your lordship will have to deal with a greater care than charitable institutions. Because charitable institutions, my lord, have a different persona in our society. They don't just claim religion. It's a charitable institution. I'm sure, my lord, around St. Teresa, my lord, as far as the charity was concerned, certainly tax questions arose and she had to answer them. That's the difference. But if you impose tax on the religion, my lord, it won't work. That is why we have to separate them. So I come to manage. My lord, there's a bit of a bogey about this. Read the word to manage its own affairs in matters of religion. My lord, we can say matters of religion, there's judicial review, is it a matter of religion? My lord, I take B to be a statement of autonomy. You have to have the right to manage your religious institution. And as was said in Sirur Mat, my lord, and I'll come to Sirur Mat in a moment, my lord, what was said in Sirur Mat was that religion and the institution get enmeshed. There are so many things that get enmeshed. Your lordship will not, my lord, as far as interpreting 26B is concerned. Your lordship, my lord, in the respectful submission will not say we'll go into whether this is an affair of religion. It is a religious institution. And if you don't give autonomy to manage the religious institution, my lord, all these institutions will fail. And that's the important part, my lord, of the word manage. Manage of religious affairs, because if it's a religious institution, you have to manage the entire autonomy of it. If you don't have that right, my lord, then we will be quibbling. Is it part of religion? Are you interfering with religion? Etc. We don't have to go that deeply into the question. This is a question of managerial autonomy. I come to the C and D, my lord, has already been placed before your lordships. Can you imagine a religion, my lord, surviving?
You're in line with Mr. Vaidyanathan's argument?
Yes, my lord, to some extent.
Consonance with.
My lord, I am online with him, my lord, also on the question, my lord, of 25(2)(b).
Yes.
And the relation with 26. I'm entirely with him.
Supervening 25(2)(b) is his argument.
Yes, yes, absolutely. I'm with them. That's why, my lord, these are nuances. And I accept that nuance. Take away the autonomy. You go to a religious institution and you say, by the way, this is not part of your religious affairs. He says, look, my entire institution is part of my religious affairs. I take issue with Mr. Singh. My lord, I hate using the word doctor, my lord, because my doctorate was 53 years ago. It was just another degree. So I never signed myself as doctor, but it's become a habit on both sides, my lord, to say Dr. Justice, Dr. so-and-so, or senior counsel, Dr. so-and-so. Lord, these are just degrees. A person having an MA degree may well say, I want to be called master. Let's leave all this. But I make the mistake sometimes. I say Mr. about somebody or whatever, my lord.
But
Now, come
even
to
honorary doctorates, they like to have it
it's
as.
even worse, my lord. I was offered one, I declined. Anyway, we come to property, my lord.
Justice Bagchi.
I'm sorry, my lord. My lord, your lordship will have to speak just a little.
Will you agree that manage religious affairs, either denomination or
No,
secular?
just 1 second, my lord. There is a.
Will you agree that the word manage?
Sir, थोड़ा बैठ जाइए 1 मिनट के लिए एक प्रश्न है I'm sorry.
Mr. Dhawan, will you agree that manage religious affairs of
Yes.
26(2)(b)
Yes.
are congruent, not on the institutional and individual, but congruent in its activity with the words freely, write, freely, practice, propagate religion? That's the second limb of clause 1 of Article 25. How do you read these?
My lord, I would not subject Article 26 to Article 25(1). Your lordship has also asked that question, whether a denomination is a compendium of individuals.
The reason why I ask is
Yes.
managing affairs or managing religious affairs is the external expression of the religious beliefs. And will there, therefore, not be a congruence between freely practicing, professing, propagating religion, that is the second limb of Article 25(1),
I follow.
and managing religious affairs,
Lord-
that is clause B of 26?
My lord, the important word in your lordship's question is congruence. Congruence, my lord, can be, it takes color from it, without subjecting itself to that article. Because autonomy requires not subjecting yourself, my lord, to that particular.
Why
So
I asked, why I.
Not only is it textually missing, my
You're
lord,
right, you're right.
but I'm not on textual interpretation. my lord.
But if Mr. Dhawan, your arguments accepted, then the subordination of the individual with the words subject to other provisions, as well as, and more definitely with regard to the legislative enabling powers of 25(2)(b) would be rendered nugatory by the individual professing the same right through the institution under 26(b).
Let me divide that, your lordship's
This is
question,
where
into two.
I need a clarity.
My lord, as far as 25(2) is concerned, I've already made my argument that 25(2) is a very important social reform secular. And therefore, my lord, it is an important and virtually unlimited right in that sense.
Unlimited right.
Unlimited. Unlimited in the sense your lordship will interpret whether it's social reform or not. Your lordship will also interpret whether this is secular or not.
So you agree that when the legislature, in its honest pursuit of a social reform, brings in a statutory regulation, it would definitely have its impact also on Article 26B.
As long as the nexus between,
Until and unless the
Nexus of
interpretation of hollowing out the
Yes,
religion,
that
or
has to be hollowed.
changing the religion
that
as
has to
its
be hollowed.
whole, where I put this question, the issue of integrality
yes,
of the practice and the profile of the religion may become relevant.
now, my lord, 25.2, my lord, has an integrity of its own. 25.1, your lordship may be right in this respect, that it is part of the vision of the Constitution.
Mr. Dhawan, I understand and I appreciate what you say. In case of a conflict between the individual and the denomination with regard to interpretation of the managing of its affairs
Lord,
and the professing of religious practice of the individual. But when it comes to the state and the state's legislative sweep, 26, if held as a separate assailable island,
That's
it
right.
would become
No, I wouldn't call it an island, my lord.
remit of reforms.
I wouldn't call it an island. This argument of separate articles being silos, my lord.
Yes, it's
Obviously, we have to integrate them, my lord, to some extent.
Thank you.
I don't accept
Thank you.
the argument of
I understand.
Mr. Singhvi on
I
harmonizing.
understand.
But, my lord, what your lordship is actually saying, if this gets out of hand, that's why I said certain parts, my lord, of our constitution are constitutional statements, my lord. Equality is a statement. It's not a limitation, it's a statement. Untouchability is a statement. Anti-exploitation is a statement. They will certainly, my lord, to borrow my Lord Justice Amanullah's view, it will certainly enter your lordship's conscience.
That, sir, would definitely be in the opening three interdicts of morality, health, and public.
Absolutely right. And that part, my lord, was answered in my view, though it was, I think, my lord, he took a rather expansive view. That was what just Mr. Vaidyanathan said to your lordships, that there is a limitation, but it is limited in these areas. And morality, my lord, has its own interpretation, not constitutional morality. It has its interpretation. And that morality may take into account 25.1.
Equality.
That's what I'm saying. And to that extent, my lord, I'm with Mr. Vaidyanathan on the interpretation, though not to the extent of it.
Of completely blocking out social reform legislation.
Absolutely. Therefore, I'm not, my lord, on 25.2, I'm not with him, my lord. But otherwise, my lord, I hope I have answered your lordship's question. Now, my lord, let me come back here. Property. Can you imagine, my lord, a denomination or an institution, religious institution without property? You can't. And when it says according to law, it means according to reasonable law, as your lordship has held. Not just when it says to administer such property in accordance with law, it must be reasonable law, my lord. It can't be anything else. So, my lord, this is my interpretation. I now come to 27 and 28. I know Justice Nagaratna said, why are we going to 27, 28? I'll tell your lordships the reason. My lord, the American Constitution has an anti-establishment clause. The state cannot enter into any religious question. The latest cases suggest that even if you are an employee in a church, employment law will not apply to you. Now, my lord, this troubled our constitution makers. They said, should we have an anti-establishment clause? The state shall not enter into anything religious. They threw it out. 27 and 28 is the negation of the anti-establishment clause. They say we will apply it in only two areas. 27, no taxes for a particular, no compulsory taxes for a faith. 28, if it's a state institution, no compulsory religious instruction. If it is aided, then you cannot be compelled. So we took a very limited view, my lord, of the anti-establishment clause. Because had the anti-establishment clause been wider, everything would have fallen. All religious, my lord, beliefs would have fallen, everything would have fallen. Because the state would then say, we can enter into it or can't enter it. Today, my lord, we have to enter into it. The state today celebrates all religions. This matter arose in 1966, my lord, in the Delhi High Court, where they said, why are we celebrating Lord Buddha? And the answer, my Lord Justice Deshpande gave was, because we celebrate everything. We celebrate all religions. We don't have an anti-establishment clause. And that's important for that reason. This is a limited anti-establishment clause. I now come to 30. And then, my Lord, I'll be as fast as I can, my Lord, as promised. And whenever your Lordship asks me to stop, I'll stop. Now, my Lord, 30 is important for this reason. It uses the word 31, established and administer. Now, established and maintain is used in 26. Therefore, my Lord, this clause became a very difficult clause because in Siddharth Bhai in 1963, His Lordship Justice Shah said, 30 has no limitation, it is absolute. And one of these questions that came up in TMA Pi. So TMA Pi said to say it is absolute, even though there are no limitations there, is an overstatement. The question then arose is, you have educational institutions. Remember, my Lord, under 26B, in para 26 of TMA Pi said, 26B includes the right to establish educational institutions. Now, my Lord, how do you control these institutions? So what TMA Pi effectively did, my Lord, was to say that all the normal laws of the land will apply to you. They have to apply to you. Therefore, if it's a hygiene question, it will apply to you. If there are some workers' rights involved, it will apply to you. If tenancy is involved, it will apply to you. And therefore, my Lord, by creative judicial interpretation, even though there was no limitation in Article 30, none, your Lordship, by judicial interpretation, said that, look, certain things will apply. Otherwise, they'll become a law unto themselves. And that, my Lord, apply.
Right to administer does not mean right to maladminister.
That's right. That's right. You can't maladminister. And if you then don't accept these limitations, you will be maladministration. Your Lordship is, your Ladyship is, my Lord, one never knows whether to say Lordship or Ladyship. And I used to say this to Justice Ruma Pal, and she said, apply the General Clauses Act. Man includes women. But leave that, my Lord, for the moment. So just, my Lord, even if there is no limitation.
Actually, the word woman includes man.
Absolutely. Let's leave it there, my Lord. And this, my Lord, is a matter of interpretation.
Because she includes he.
Absolutely, my Lord. The other way around, absolutely, my Lord. Now, my Lord, I come back to my text, my Lord. I will not use the Constitution anymore. And let's come back to my text, my Lord. And where was I? I'm sorry, my Lord. Now, my Lord, kindly come to page decoding, my Lord. That is on page 5. Much of this, my Lord, I've already put in oral argument. So I'll be very quick about it. This is, my Lord, my arguing note now. Has your Lordship got it? No?
Yes.
I'm on page 5. I have already argued, my Lord, 3.3, freedom of conscience. So I'll leave that. I've already argued the link with Kaushal Kishore over the page. I've already argued 3. Freely too. So, my Lord, I will not place that before your Lordships again. Now, my Lord, kindly come, my Lord, to this question of practices and propagating the faith, which is on 3.9. Lord, the word practices has to be interpreted. In 3.10, my Lord, I submit to your Lordships, the practices are not just practices in temples, mosques, churches, mats, but also social practices. That is why practices is put there. There may be social practices connected with the faith. Those practices, my lord, will also come in the limitations that exist. Because, my lord, we are constantly arguing this whole question of temples and entry. But let us, my lord, go a little further. There are practices, my lord, connected, intimately connected with religion. That is the reason why, my lord, we have opening the practices. That is the reason why we say some regulation must be there. So practices here, the right to practice or practices is not just going to temple for prayer. It is your social practices. So when there is a havan every morning, my lord, in our house, that's a social practice. It's not associated with the temple. My lord, I used to go to church, my lord. Now, in a Catholic church, my lord, they allowed me everything. They allowed me to enter. But when I wanted to take mass, they said, no, you can't have mass. I'm sorry. The bread of Christ and the wine of Christ will not be administered to you, my lord. The next thing I did is went to a pub and had some beer. But we'll leave that aside, my lord. Now, my lord, the right to propagate is an important right. And proselyting faiths, my lord, are not just, as the Constituent Assembly thought, that proselyting faiths are just, my lord, Islam and Christianity. No. My lord, what is ghar wapsi? I ask your lordships. Is that proselyting? We do it all the time, my lord. So proselyting is there for every faith, my lord. There was a confusion, my lord, because Ratnaswamy, my lord, Mr. Ratnaswamy, my lord, there were the committees, there were subcommittees, Fundamental Rights Committee, Minorities Committee. They went to an advisory committee, that went to the constitutional advisor, and then Ambedkar did the constitution. So, my lord, in my respectful submission, proselyting is there in a large number of faiths. I gave your lordship the example, my lord, of the Nazarene Jesus. Now, my lord, you create mutts, they're also part of the institution. You create other social practices. The Hare Krishna group, my lord, is before my, I don't know why, they come every other day to my house, my lord, to proselyte. Do you believe in Krishna? I said, of course I believe in Lord Krishna. He's the most interesting God of all. Now the question is, proselyting does not affect Christianity and Islam. That's all I will say, my lord, and I'll move on. I've already, my lord, done 3.16, that this is the most crucial right of all. Without religions will fail. And then, my lord, I gave an example. Had there been no St. Paul, there would have been no Christianity. And certainly Shankaracharya added to the mutts. Now, my lord, I come to 3.19.
There is a distinction between proselytizing and propagating.
Yes, my lord.
There's a fundamental
My
difference.
lord, the reason why I'm expanding this, my lord, is this, that in the Constituent Assembly debates, Mr. Ratnaswamy introduced this because there were certain proselyting faiths that had to have the right to propagate. And this is interpreted in Stanislaus by your lordships in 1977. He said, you can do whatever you want, but no coercive conversions. That's the law your lordship has laid down. That is my lord, the Chief Justice mentioned it, my lord, earlier on the first day. Now, my lord, I've done with religion, 3.20. Now, my lord, I come to a very important point. That is, my lord, on the top of page 8. My lord, I'm not going to repeat, my lord, because what I was better orally explained, my lord. Now, my lord, I want to, my lord, get into the juristic techniques of limitation. Why do we use different words? Now, my lord, 3.22, subclause 1. The limitation is by its very nature regulatory and restrictive. So when there is a limitation, subject to so-and-so public, only thing I add there is it will be subject to reasonableness and proportionality. The next is, my lord, when we use the word subject to. Now, this is a very difficult phrase. And in a sense, I don't know why this is squeaking, my lord. I thought it was my earpiece. It might be, my lord. And that answers my Lord Justice Bagchi's questions to some extent, my Lord. When we use subject to, my Lord, it's a very powerful subordination. I counted 53 instances, then I got tired, my Lord, where subject to is in our Constitution. In federal cases, mineral rights, this has an entirely different meaning. Here, when we say subject to, it is a very powerful statement. And this is why I distance myself from Devaru. He made 26 subject to 26(2)(b). So subject to has a different juristic technique altogether. So when that is used, my Lord, it is a system of subordination. It doesn't become just balancing, my Lord. It becomes an instance of subordinating something to something. And I believe that was not intended by 25 and 26. That part, my Lord, in my respectful submission in Devaru is wrong. Because Devaru said they are both of equal importance. If they are of equal importance, you must give effect to both. Simple. So this, my Lord, juristic technique has to be understood. Then, my Lord, the next is the question of harmonization. Now, my Lord, harmonization was used by Mr. Singhvi about 20 times, my Lord. Whenever your Lordship asked your Lord a question, Mr. Singhvi said, your Lordship will harmonize. My Lord, if harmonizing is what your Lordship to do, we can pack up and go home, my Lord. Your Lordship will harmonize everything. Harmonization is a technique that is used when there are two provisions of co-equal authority. Therefore, you can't use the word harmonization, my Lord, as just an extra jurisdictional technique. When you ask a judge, judge asks you, what should we do? We say harmonize. But harmonize, my Lord, has a particular context. And the context is the problem arises when there are two co-equal authority. Now, this Devaru accepts. Nowhere is it written subject to, but Devaru says there are co-equal authority. Then, my Lord, the next question is, I will leave that, my Lord. And then, my Lord, as I've mentioned in 3.22 sub 6, there are certain declaratory parts of a constitution. Untouchability is a declaratory part. I would say anti-atrocity is a declaratory part. Anti-exploitation is a declaratory part. So I leave that. Now I want to say one thing, my Lord, because it arose before your Lordships, and I think my Lord, the Chief Justice probably hinted at it. All fundamental rights can only be invaded by law. It can't be done by any question came before your Lordships the other day, my Lord, about the national song, my Lord. Your Lordship will remember that. Now, your Lordship accepted that it wasn't a law. But went on to say, don't give us frivolous PILs. That's a different issue, my Lord, altogether. Now, it comes in Ram Jawai Kapoor. It's a very famous statement of my Lord Justice B.K. Mukherjee. Because he said, you have to have law, you can't. And then it goes all the way, and the actual, my Lord, ratio of Bijoy Emmanuel is that there was no law. That is the actual, my Lord, ratio of Bijoy Emmanuel. The rest, my Lord, was added on. He could have disposed of the entire case by saying, you have no law. Sorry, it's just a declaration you have made, and therefore Jehovah's Witnesses have their case. So, my Lord, kindly bear in mind the distance between a limitation, which is a law, and an enabling legislation under 3.2. They're of a different genre altogether. An enabling legislation, my Lord, has a life of its own. Now, my Lord, I come to public order, morality, or health. I won't, my Lord, bother your Lordships with all this public order business. Ram Manohar Lohia has been read. Only thing I would say is that the state often says public order when it means law and order. And that is something your Lordship has faced when protests come, my Lord. But I come to morality, and I'm answering something that was said by my Lord Justice Bagchi, unless I got it wrong. Morality means, my Lord, it has two components. The first is, my Lord, normative. It means in the Kantian and Gandhi sense, something that cannot be violated. That simply can't be. Gandhiji took a very strict view of this on cows, on vegetarianism, on whether you can kill, whether there should be violence or non-violence. He was clear, normatively certain things cannot be done. The other meaning, my lord, of morality is pragmatically. What do we mean by morality? I prefer the phrase used by Francis Bacon in his Novum Organum, one of the very radical statements. He says, morality is not the morality of the marketplace. And that puts it much better than popular morality. It's not the morality of the marketplace, my lord. How can it be? Everything happens in the marketplace. Popular morality becomes very elastic, and we have to be sure as to what we are talking about, my lord. Now, my lord, number 3, my lord, here, closer home, it means morality which a civilized society would not countenance. I'm moving away, my lord, from the definition of my Lord Justice Nariman, who said it should be abhorrent. Now I'm saying it's a little higher than that. It should be what is, oh God, may I, my lord, just, this is squeaking away. I won't be able to hear your lordships properly, but let that go, my lord. They will tell me what your lordships have said. So, my lord, what is it? It's not abhorrent. That is the footnote, I think, in para 176 of Sabarimala. It's not something abhorrent, my lord. That goes far beyond. Therefore, my lord, the morality that a civilized society, and by which I don't mean international, I don't mean Mr. Trump's, my lord, civilized society. I mean our civilized society. That would be, my lord, my reckoning of morality. Then, my lord, I come to health. I'm grateful to Mr. Subramaniam for this point. My lord, he distinguishes between two in his written submission and in our conversation. It includes personal health and public health. Personal, suppose somebody says you must have a smallpox. These cases have arisen in America. I have to, my lord. It's a question of my personal health. Your lordship says I can't commit suicide. I have some problems with that judgment, but that is, my lord, my personal health. Public health, my lord, is much wider. And it arose dramatically in certain cases that Mr. Subramaniam, I borrowed from him, in COVID. When I went to Apollo, they would not give my place to a poor person, so I walked out. And then they said, look, personal health, you must do something about it. That was personal health. Public health meant if you're going down in a procession, you're going inside a temple, and you're gathering. Now that, my lord, is a limitation that is imposed even inside a temple. And I looked up the statistics, my lord, of what happened in Tirupati and other temples. My lord, they got no earnings. They had to rely on their reserves because there was a COVID ban. And of course, some temples, my lord, had a lot of earnings. They had a lot of reserves. They survived. The ones that didn't have earnings, my lord, did not survive. I have the statistics somewhere, but it's irrelevant to this case. Then, my lord, I come to secular practices. I've already argued this, my lord, and therefore I will skip it. Because what I'm arguing is there is no collision course between secular practices in the universal sense and religion. This collision course is not there. Now, my lord, what are the examples we take from TMA Pi on what is the meaning of secular? I've indicated in my own terms in 3.29. Laws related in terms of their identity and trust societies, charitable companies. You have to comply with company law. Second, terms of contracts, property, and other dealings. Tenancy, you have to comply. This is an add-on, my lord, which will always be there. It was there in TMA Pi. It will be there for all institutions. Then, my lord, taxation. Educational institutions will be subject to regulation. General principles arising from general laws, general regulation of property rights, general obligation of health. Now, my lord, I come to social reform. I've argued the bulk of this, my lord, orally. So if your lordships will kindly come to page 10. Your lordship's judicial interpretation will decide whether it's secular activity or not. But I put here in 3.33, I disagree with Dr. Singhvi's argument, which was a spatial argument separating right of entry. And that is the question my Lord Justice Varalavi put to him. You go to a temple not just to enter the precincts. He said, once you enter, your rights are over. It may mention entry. You go there to pray. And therefore, my Lord, the distinction is not a spatial one. Once you enter the premises, your right of entry is over and the right of the denomination starts. Your right is there to pray. And that has to be, my Lord, adjusted, not just entry simpliciter. I'll just put that point, my Lord, to your lordships, and I'll leave it there. Because that interpretation, and that's the question that was put by my Lord, that once you enter, the question also of choice, you can go to some other temple. That's not the point. I want to go to this temple. It is the most important temple. I want to go there. The second is, what is my right of entry? Is it just to cross the perimeter? No, my Lord. It is a right to worship. That is the right I have. I have the right to go to any part of the temple, and possibly, as Mr. Vaidyanathan argued, not the inner sanctum. That part, my Lord, of the Devaru judgment is probably correct. That you can say, you come to any part of the temple. I wanted, my Lord, in Madurai, I went to the temple, I went all the way, then they stopped me at some point in time, some prayer, etc., and offering, and it's the priests that do it. So that part, my Lord, of Mr. Vaidyanathan's argument, I accept entirely. Now, my Lord, interrelation between 25.1 and 25.2. Well, I'm going as fast as I can, my Lord. But if I was not saying something different, my Lord, I wouldn't address your lordships. Lordship may accept it or reject it, my Lord, that's up to your lordships. Now, my Lord, I've already explained in 3.38 why 25.2 has to be protected from 25.1. And, my Lord, I have already indicated to your lordships, and it has been read many times, what was the discomfiture of my Lord Justice Iyengar when he said, are you swallowing up the right? And I've indicated what Justice Nariman said, adopting the argument, but saying, look, this will have to be decided in some other case, which is this case. Now, my Lord, harmonization I've discussed. I have some difficulties, my Lord, in accepting parts of what Mr. Vaidyanathan has said, and that is, my Lord, in 3.42. This, my Lord, and I don't think he meant it, my Lord, because he was going under the limitation. Mr. Vaidyanathan took an extreme view on the right of denomination sampradaya to arbitrarily all from temples if they wanted to do so. This, my respectful submission, is an overstatement. A correct harmonization would be to give effect to both. And then, my Lord, there is some disagreement on Seshamal. I don't know how much with your lordships want to go into it, my Lord. My Lord, Seshamal has two elements in it. And I will read it from here. Mr. Vaidyanathan's implied view on Seshamal and on decisions abolishing hereditary trustees must be subject to social reform legislation, so that if an SC/ST, non-Brahmin, is trained and learned in the faith and agamas, he may be appointed externally, because internally he will never be appointed. Because here we are on social reform, my Lord. There is somebody, my Lord, it's a eklavya, my Lord, principle.
Is that externally and internally?
Sorry, my Lord?
What is the meaning of this, externally and internally?
External versus internal, my Lord. Because what the statutes say, that the appointment, if he is learned in the agamas and he's trained, then He is entitled to be appointed even if he is not a Brahmin. If you leave it to internal, they will never appoint him. Within the faith. Within the faith. Within the faith, he will never be appointed. Now, this, my lord, is part of my Lord Justice K. Ramaswamy's judgments. And to some extent, this reform is important. Supposing there is an ordinary person, my lord, scheduled caste. They love your doctrine, my lord. He's learned everything. He has learned the agamas. And my lord, even the commission report of 1962, where Kane, Venkataraman Iyer, my lord, gave evidence, even they suggest that, look, hereditary trustees, if you want to abolish them, abolish them. But the trustees, whoever is appointed, must be trained and in the agamas. That is the distinction between external and internal. Now, my lord, I come to, I leave the rest, my lord, that's only a conclusion. C.P. Ramaswamy. No, but Venkataraman gave evidence. My lord, if your lordship doesn't have that report, my lord, I'll put it in your library. It is the only report we have on religious endowments with C.P. Ramaswamy Iyer.
1962 report.
Sorry, my lord?
1962 report.
1962. Now, my lord, I will now deal, my lord, with the question of denomination. To some extent, I've already dealt with it. My lord, denomination and sect has to be given an Indian meaning to your lordships, not an Irish meaning. I don't like the phrase Mr. Vaidyanathan uses of Abrahamic faith. Abraham, my lord, if he ever existed, disappeared a very long time ago. There are, my lord, even Kitabiya faiths, my lord, have all kinds of interpretations in them. But anyway, my lord, okay. My respectful submission there is that this should be interpreted as covering all institutions of the faith, because it's an institutional right. We can't, my lord, be dragged into meanings of denomination or sect. We can't, my lord. It doesn't apply to us, my lord. Therefore, when you interpret it creatively, you will say all groups, all institutions of the faith, whether it's a tribal faith or a church or a mosque or whatever it may be. Now, my lord, I want to place before your lordships one aspect of Sirur Mat. If you judge, my lord, Sirur Mat by what was actually decided in the case, then, my lord, let us see what happens. That is 4.3. In Sirur Mat, let us see what was struck down. Section 21, empowering commissioners and officers to enter religious institutions. Nothing to do with religious affairs, my lord. Second, 31 so-and-so, powers of the Mahant in relation to surplus income. Struck down. This is part of the management of the institution, my lord. Section 31, use of surplus funds and sanctioned by the Deputy Commissioner. Struck down. Section 555 on the power of the month to spend only for the purpose of the month. Struck down. Section 56 on the power of the Commissioner to appoint a manager. Struck down. Chapter 5 on 63 notification, especially with access to rot to set aside, struck down. 70 on the power of the Commissioner and Area Committee, struck down. 76 contribution, my lord, that is a question of fee and tax, which your lordship struck down. Now, what was it trying to protect? It was trying to protect the institution in its totality of management. Forget him saying that this ritual also has other elements. The same, my lord, comes in Ratila. A charity commissioner cannot be a trustee. Ratila. This has nothing to do, my lord, with the next, the CPRE doctrine will not apply. Struck down, not applicable. Then come to, my lord, the third case that has not been mentioned in 1954. There were 3 cases. And in Jagannath, my lord, also, my lord, it was struck down. It's on 2, that a scheme could not be framed by an executive officer. Well, what does this have to do with religious affairs? Because the interpretation was management and autonomy of the institution. That is the ratio of these three cases, my lord. Now, my lord, I will complete denomination, my lord, after lunch, if your lordship will give me just a little bit of time. Now, my lord, there is a huge confusion about applying the concept of denomination in your lordship's court.
The management of the institution is different from manage its own affairs in matters of religion.
My lord, what I'm saying is religious affairs includes the institution. Some parts of it are inseparable. You can't say this part is religious affairs and that part is not.
Therefore, it was rightly struck down.
Yes, that's right, my lord.
Yes.
And that is why all this was struck down. And that is the important part, my lord. If you can't manage your institution and religious affairs are enmeshed in the institution, then, my lord, where are we? Now, my lord, when your lordship started this case, I said denominations need to be, and your lordship said it's part of 1 and 2. My lord, there are 3 kinds of cases on denominations, and that, my lord, kindly come to 14. The first classification is who was treated as part of the denomination. I won't mention the cases, my lord, that's there. The second part is where a faith is not a religion, but they treated it as a denomination. Or Bindu. And my lord Ramakrishna. The third is that some faiths are not entitled to denominational status. Now that is, my lord, part of Sabarimala. They said you are not entitled to denominational rights at all. So 26 disappears. That very vital part, my lord, of 26. Your right to the entire, that disappears. 26 disappears as soon as you are not recognized as a denomination or sect. And that, my lord, as I've explained, was the difference in 4-1 in Sabarimala.
Is there no protection to non-denominational temples then?
No, my lord. I'm not on that part, my lord. They denied denominational status, the majority, to the Sabarimala institution as it existed, my lord, with Lord Ayappa.
What follows?
What follows is 26 disappears.
Correct. That means 26 is only for denominational temples.
No, but I'm saying it is so.
To
My lord,
temples have they no protection?
my lord, what I'm saying is, if your lordship goes away from denomination or sect for a moment and say social religious institution, then, my lord, they will get their denominational rights. And Lord Ayappa will get the denominational rights.
So we want to know, is there any religion which can exist or without having a denominational, having a denominational color?
Lord, what I'm saying,
having protection.
Lord, what I'm saying is this. If you take a wide view of denomination, and all religious institutions demand that, then they will get the protection to religious and charitable institutions, manage their affairs, property rights. If you take it away, my lord, then they will get no 26 rights.
That means, for example, let us take the example of Hinduism, like Shaivism, Vaishnavism, Sri Vaishnavism, whatever isms, etc. are there in Hinduism. Everything is a denomination, then they get protection.
My lord,
are you trying to say that?
What I'm saying is denomination there is a misnomer that we have taken, unfortunately. We have to protect the institution, the religious institution. Now, the reason for this is, my lord, just bear with me for a minute. There was a 4-fold step taken from the Oxford Dictionary. Now I come here, my lord. 4.7.
Outside is 26.
I hope I
And they
was really saying is, if you give a narrow meaning, 26 will disappear. If you go a wider meaning, all religious, then the institutional rights of 26 will inhere. The mistake possibly in Sabarimala, which will be decided by your lordships, they gave no denominational status to the Ayyappa temple.
Yeah.
Now, my lord, one point here, and then I'll finish as quickly as I can. I'm sorry, my lord, I'm asking for indulgence. I'm not asking for your lordships to sit overtime.
May I just?
No, Mr. Dhawan, if you want to finish, we can continue for another 2.
My lord, I'll deal with one.
If you need, say, half an hour.
page 14 of my argument note.
Three classifications.
I've given your lordships, my lord, the examples. But there is an irony. You say you are not a religion, but you are a religious denomination. Now, all this has to be sorted out. Now, how did this occur, in fact? That is what I'm explaining at the bottom of page 14. The Oxford Dictionary, broadly speaking, says what I say in 4.7. The fourfold test: you must have a common belief, collection of individuals with common faith and I've added organization, distinctive name, deprived many organizations, and distinctive name. Now, what these judgments, my lord, effectively did was, and that's what happened in Sabarimala. They said you have to show an exclusive distinctiveness. So they said that, look, there are so many Ayappa temples. Why are you distinct? Or why is this place distinct? Therefore, my lord, that super added fifth test, that you must show that you are exclusively distinctive. My lord, that was the mistake. And my lord, therefore I say, at the top of page 15, it is submitted that the term denomination must be to cover all religious faith that have a common commonality bound by a common purpose and institution, you might add, including rituals and includes all sects or subsects. And therefore, the logic of exclusion from denomination status has been to add a fifth element of absolute exclusive distinctness in Sabarimala. If this fifth element is taken as an overriding test, many religions will lose the important and crucial institutional protection of Article, it should be 26, my lord.
Yes,
Lordship may correct. And Sabarimala must be overruled in this regard. Now, my lord, I come to a question. I'm sorry, my lord.
Someone, at this juncture, could you enlighten us also? Why could religious denomination include a religion standalone also?
No, my lord, suppose.
Discussed as one separate to be inclusive. Religious denomination may mean a full-fledged religion itself also. It can be called it is a religious denomination. It's a wider definition of religious denomination.
Your lordship is
like
right.
a non-denominational, what had fallen from my sister, they get covered into that.
Your lordship,
With that interpretation, I think
My lord,
it balances many of the questions which may.
my lord, the point here is, this is located now in Article 26. Therefore, your lordship will have to interpret it in the context of article. In social life, of course, there will be denominations.
Not social, even in religion. Why can't a standalone religion itself be a religious denomination?
My lord, as far,
Why can't we give that interpretation?
my lord, according to my interpretation, it can be, my lord. There is, of course, a proliferation that will take place of religious denominations.
Include subsects or otherwise, that is yes. But standalone, alone it can also be called a religious denomination.
My lord, I have no,
Let's say per se.
my lord, I have no quarrel what is falling from your lordships and her ladyship. No quarrel with that. And therefore, even if it's a small place, it will be a denomination. If it's a religion, the question is, you have to show a commonality that makes it distinct to have institutional rights. That is the point I'm making, my lord. Because we are interpreting it in the context of 26 to grant them the rights A, B, C, D. That's why, my lord. Otherwise, your lordship is entirely right, my lord.
So that means for a religion, it does not have to derive that it has to be a set connected to some major, otherwise bigger entity. It may not be.
No, my lord, I'm saying precisely that. It need not be. It need not be, my lord. Even the smallest tribal religion is entitled to be called a denomination with institutional rights. Your lord, I misunderstood her ladyship's interjection. I'm sorry.
So
Your lordship is absolutely right. It isn't the major faiths, my lord. It isn't the major faiths. That is why I began, my lord, with my 5 points. Your lordship is right, my lord. Now, some of my colleagues may take the view that this huge proliferation should not take place. They will address you on that, my lord.
Mr. Dhawan, you say that the commonality need not be unique to the denomination.
Yes.
then how do you distinguish one denomination from another?
My lord, they will all be entitled to institutional rights.
How do you distinguish one
My lord, you
denomination
don't-
from another?
My lords, your lordship,
A
I'm sorry.
denomination must have an identity.
Yes, 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 yes.
And the identity
Yes.
must be unique to that denomination.
Yes, yes, sir,
Now,
absolutely.
in that respect, how do you distinguish the commonality of one denomination with the commonality of another if there is no uniqueness?
My lord, your lordship is right.
As you said, let's not use Sabarimala because we're not going into Sabarimala. Let us say someone is a worshipper of God X, and there are a number of temples worshipping God X. Now, in this situation, a particular temple has certain unique practices. Will that temple having unique practices to worship God X be defined as a denomination and thereby exclusivity in respect of its common practice?
Yes, my lord. Your
So
lordship.
there will be
my
a
lord,
uniqueness.
What it will require is a group of worshippers that have an identity
So,
and
I'm asking
a
this,
commonality of purpose, my lord.
correct, sir? Commonality is to the members of the denomination.
Yes, yes,
But
absolutely.
exclusivity is in relation to other denominations,
Yes, yes.
other sections.
Yes, ma'am.
So the exclusivity test should also be there to define a denomination.
My lord, it's very difficult sometimes when there is an overlap of denomination that they believe in this, they believe in that. My lord, this often happens when there are syncretic faiths. For example, my lord, in Makatola in Punjab, it's a syncretic faith. The Sikhs go there, my lord. The Christians go there, everybody goes there. Now they also have their own gurdwaras. So there is an overlap. So in this overlap, certainly you will give an identity to Makatola as a syncretic faith. You will also give an identity to where they go by way of Gurdwara or otherwise.
What I would say is now,
Sorry, my lord.
the right to have an association or a religious denomination
Yes,
is a recognized right under the Constitution.
yes,
So let us say a private belief.
yes,
You can have, all of you can be the worship of Lord Shiva,
yes,
but despite the same commonality, they can have individual groups.
yes, yes, my lord.
So long, it gives a flexibility. Ultimately, the decision of the common believers.
Yes.
So a 10% can say, all right, we form a group. We have a religious denomination. We have our own properties. We have our own thing. The another 25% can say, all right, we'll have same different denomination. So long as say they have that mind, and the idea is to join together with the common belief and then constitute a religious denomination, that would be fine.
That is why it was
I have no quarrel with that. The proliferation that takes place is not a problem.
That's not-
Once you become a denomination, you can establish and maintain.
That's correct.
Once you become a denomination, the Constitution recognizes that.
You represent the common
Therefore-
belief of the members there.
Therefore, the overlap may be there, Malo. And I'm not resisting a proliferation. I'm sorry, Your Ladyship.
That is why it was said, Sampradaya becomes relevant. Normally, you see in marriages, what happens when you go to see a bride or to see you ask the bride's family or the grooms, to which Sampradaya do you belong?
My Lord,
They all are Hindus, but then they want to know whether you're Shaivite,
Hindus,
Vaishnavite, Sri
absolutely.
Vaishnava,
And your Ladyship put that question on entry of temple. Why can't a Vaishnavite go to?
They are saying denomination means, Sampradaya means the system of religious practices vis-a-vis that particular deity. That is Sampradaya.
Date,
That is protected under 26.
with or without a deity, it doesn't make a difference.
Yes, normally we are saying
Ultimately,
My Lord,
yes,
Your Ladyship,
same thing happen to non-Hindu religions also.
my Lord, my instant response to that is that sampradaya is an easier term to interpret than denomination or sect. It's easier because once you get into denomination and sect, you're back to the Irish, my Lord. That's a difficulty. When I was in Ireland, my Lord, they used to ask me,
The Indian equivalent, Indian word to denomination then. What is the Indian meaning?
I imagine what was
Indian context.
I imagine what was intended, and we'll take it from the Hindi constitution, was a community. A community that has a commonality and a set of beliefs a common organization and name. Name is important.
We don't know what they have written in the Hindi version of the constitution.
No, so my lord, we use Sampradaya, but Sampradaya does not have all the elements that have been described by your lordship in your judgments. So, your lord,
Whatever we say could at best be an illustrative one. Because it might differ from person to person, group to group.
Group to group.
So long as the common idea is there and the object is to conform to your rights guaranteed under 25(1)(a)(1), that would be fine. You have a common belief, then you profess conscience, profess, practice, and protect. For
And
that purpose, you have your own group.
And
And that group will have set of rules and then property management, maintenance, whatever it will may be.
and a togetherness.
That's all right.
That's what it is.
Should not go too deep into this.
That's why I'm saying Sampradaya is not a complete definition of what would get into 26. So your lordship will have to interpret. It's a much easier term to interpret than denomination or sect. And therefore, my lord, I accept that part. I'll tell your lordships, my lord, in answer to what my lord Justice Bharti said when I was in Ireland, they kept asking me, who are you? What's your religion? I used to say, I'm a Hindu. And they used to say, but are you a Protestant Hindu or a Catholic Hindu? Are you a Fenian or a Prod? So, my lord, I said, I believe in your Protestant and Catholic, but I am a Hindu. Commonality, my lord, is the important thing. Overlaps will exist. There will be a proliferation, but we must accept that.
So whether.
But my problem with the Sabri, I'm sorry.
The denominational practices can be the subject matter of judicial scrutiny.
That's right. Absolutely, my lord.
Whether it can.
Your lordships will have to decide the entitlement to 26.
And what happens to the content of Article 26?
Sorry, my lord?
What happens to the content of Article 26?
My lord, the content
Court
of
starts
Article
interfering.
26 is, once you are a denomination, it gives you certain rights, the Constitution.
Where do you draw that line?
My lord, I at present, my lord, it's for your lordships to draw that line, not me. Your lordships will have to examine on the facts stated before your lordships whether it qualifies or doesn't qualify. That, my lord, your lordship will have to decide. My three categories that I have mentioned were not rigorous enough.
That's why you have called it juristic confusion.
That's right, my lord. It's very there is a juristic confusion there, my lord. Your lordships will resolve it. And as my lord, the Chief Justice put it when we started, certain things will have to be partly or wholly on a case-to-case basis. But I'm saying not wholly on a part, but there will be, in answer to my Lord Justice Kumar's question, certain things your lordship will have to examine. Somebody comes along and says, I'm a commonality, and please accept me as Article 26. Your lordship will say, I'm sorry, we're not convinced. We don't have it. And that takes us to my Lord Justice Bhakti's question. Maybe some things here are suited to suits, which I will answer, my lord, a little later.
Mr. Dhawan, in your answer, you actually, the thing that you say of overlap is definitely correct, that many sampradayas will have practices overlapping. But when the sampradaya exercises its identity, it must be in the uniqueness of some religious practice that it manages, which distinguishes it from other sampradayas or other sections of the same common faith.
If it doesn't have that uniqueness,
Then
it will not qualify.
It ceases to be a sampradaya.
Basic requirement.
It has to be.
So, my lord, my quarrel with the Sabarimala is they added a unique, exclusive dignity, and that was the problem. Because 4 judges went in different directions on trying to decide whether it was a denomination or not. That is, my lord, when your lordship examines that case, your lordship may come to it. I'm sorry, my lord.
Another interesting offshoot comes out from Article 26, Sampradaya or denomination. Do we attribute a juristic personality to a denomination or section like the Hindu undivided family?
No, my lord. No. With due respect, my lord. Juristic identity would be with the idol. With the idol. Malik and Malik. It's a very strange case, my lord. 3 brothers wanted to know where they should place their idol, in which home. And the case was eventually remanded by the Privy Council. So the three brothers said, in my home, in my home, in my home. And they said, eventually we have to decide on the juristic personality of the idol. It is the idol that has the right, neither the Shabbat nor the Mahant, nobody else. So to give it a juristic identity would make it a corporation sole. Like the post office.
That will not propose.
Yeah, that's what. So, my lord, let me stop there because I don't want to overstate the argument. I now am going to answer one question that was put by your ladyship, my lord. Where did this term essential practices actually come from? That is on page 15. The problem with this essential practices is that it is a threshold question. If you can't prove an essential practice, you're out. And that is what the 4 judges in Sabarimala decided. This is not an essential practice, so you're out. So threshold, you go out. And that is the objection. But I come now to answer the specific question of your ladyship. My lord, let us come to B. Attorney General, not the courts, invented essential practice. I'll read that portion. The learned Attorney General lays stress on clause 2A of article, it should be 20, and his contention is that all secular activities which may be associated with religion but do not constitute an essential part are amenable to state regulation. This was not an argument of the court. This was a concept created by one of our most brilliant attorney generals, arguing a very brilliant point. Now, what did the court do? They rejected it. The entire explanation that is given by my Lord Justice Mukherjee in all 3 judgments, they reject it. Unfortunately, my Lord, they take example here and an example there. But there is, in my view, a rejection of the essential practices doctrine. That is why your ladyship's question was pertinent. Where did it come from? Courts didn't invent it. They were made to respond to it. And they responded with many examples, but effectively they rejected essential practices because they said it is very difficult to define and you have to do it according to the tenets of the faith. And we are not going into the tenets of the faith.
The court cannot.
And the court will not.
But what happened in Sabarimala?
In Sabarimala, they said this is not your essential practice.
So it was that was the basis.
Absolutely, my lord. So threshold, you go out. So you go out of 25, you go out of 26, you go out altogether.
25.
That's the problem, my lord. And using this as a threshold text is a huge problem. Because you go out not after argument, but you go out right in the beginning. Prove to me that you have. Therefore, my lord, I pause there. And
Not a votary of essential religious practice.
that's right, my lord.
Yes.
Yes. Essential practice of religion, which wherever we put the.
Ladyship is asking you.
You're the votary.
Are you a votary of essential religion?
No, I'm not, my lord. I'm not. It's a very dangerous test, my lord. And it gives your lordships a lot of problems. And it will continue to give your lordship problems unless you attend to it, my lord. So I'm dead, my lord. Since my earpiece is gone, my lord, I have to rely on my friend, Mr. Gopal. Now, my lord, now let's see how essential practices was actually expanded very fast. Essential practice becomes a limitation. That's the first stage. You get it in Tilkayat, you get it in Dargah Committee. This becomes then a limitation. Over the page, my lord, Justice Lakshmanan then says, the arbiter of, this is a creation, my lord, the limitation of actually my Lord Justice Gajendra Gadkar. And Justice Lakshmanan says the arbiter of Gajendra Gadkar in so-and-so is to the effect that the court may have careful scrutiny of the practices to find out if they constitute an essential integral part is not in line with the above, the decisions he quotes. Now, my lord, I come to stage 2. Integral was there, my lord, in justice. It's there actually in Sirur Mutt, but no importance is given to it. It was added by my Lord Justice Gajendra Gadkar. And then, my Lord, what happens is Justice Ramaswamy then says integral is a separate test, not just essential. He says the concept of essentiality is not itself the determinative factor. He says it is one of the circumstances to be considered in judging whether a particular matter of religion or belief are an integral part. So we now got an entirely different test. The third comes, my Lord, where they say, if you remove it, will your religion collapse? This comes, my Lord, in another case, and I only quoted from Anand Marge, number 3. The test to determine whether a practice is essential to find out whether the nature of the religion will change that part of the practice. If the taking away of that part of practice could result in a fundamental change in the character of that religion and its belief, then should it be treated as an essential part. Therefore, you have to not only show that it is essential and integral, you will have to show the religion will collapse. Lord, I think it's taking, and then comes the next part, my Lord, in Anand Marge, that essential part means the core beliefs around which a religion is founded. And then, my Lord, there was superstitious beliefs. Now, on superstitious beliefs, my Lord, I personally believe that they are protected, subject to what Justice Amanullah said, that if there is an external manifestation of it, like witchcraft, for example, or prostitution or whatever, then that certainly is not part of the superstition. The reason why superstition has to be recognized is this: all religions will disappear if you subject them to the logic of scientific discovery. The test, my Lord, of scientific discovery is given by Karl Popper. Verifiability. Can you verify if God exists? Can you verify you will have his diksha? You can't verify anything, my Lord. Therefore, superstitious beliefs have to be accepted across the board. That, my Lord, closes this. I've just for fun, my Lord, had a description that I've taken from Justice Scalia on his version, my Lord, of what I think is essential practice. I'll read it, 5.6, my Lord. It is like a ghoul in a late-night horror movie that repeatedly sits up in its grave after reportedly being killed and buried. It is there to scare us when we want it to do so. But we cannot command it to return to the tomb at will. When we wish to strike down a practice it forbids, we invoke it. When we wish to uphold a practice, we ignore it entirely. Such a docile and useful monster is worth keeping around, at least in a somnolent state. One never knows when one will need it. This is, my Lord, in my view, essential practices. Now, my Lord, I come to the need for a threshold test. I'll put it very, very briefly, my Lord. My Lord, there is a need for a threshold test. Otherwise, anybody will come and say, this is my religion. What I put here, there is a need for a test so that not everyone can approach the court with spurious or non-existent faiths. This is very important. Bejo Emmanuel deals with it when it says that you must have a belief and this belief must be bona fide held. But what I'm taking cover from, my Lord, is this very important decision in a case from England, my Lord. When the genuineness of a complaint's professed belief is an issue in the proceedings, the court will inquire into and decide this issue as a question of fact. This is a limited inquiry. The court is concerned to ensure an assertion of a religious belief is made in good faith, neither fictitious nor capricious, and that is not an artifice, to adopt a felicitous phrase of Justice Iguchi in the Supreme Court of Canada. But emphatically, it is not for the court to embark into an inquiry into the asserted belief and judge its validity by some objective standard, such as the source material upon which the claimant founds his belief, or the orthodox teaching of the religion in question, or the extent to which the claimant's belief conforms or differs from the belief of others. professing the same religion. Freedom of religion protects the subjective belief of an individual, as Justice Ikovic puts it, on so-and-so. Religious belief is intensely personal and can easily vary from individual to individual, let's say group to group. Each individual is at liberty to hold his own religious beliefs, however irrational or inconsistent.
So
This is the threshold test.
there must be a belief. The rationality or otherwise of that belief cannot be gone into by the court.
Not at all, nor will you inquire into it, because you're inquiring into the bona fides. You're not inquiring into the faith.
Cannot be a subject matter of judicial review.
No, my lord. And that inquiry, my lord, has gone on in your lordship's court forever and ever. It is for your lordship to decide whether your lordship wants to do it. I take, my lord, some support from the definition of good faith in the General Clauses Act, as opposed, my lord, to the definition in the old section 52 of the IPC. It's there, 510. Anything that shall be done in good faith when it is done honestly, whether it is done negligently or not. This is the threshold test, my lord, in my view. Now, my lord, I'll come quickly to the question of morality. It has already been argued that Baba Sahib Ambedkar, when he meant, my lord, in fact, that all of us must imbibe constitutional morality. I use, my lord, for our rulers, officers and others, a different test. In my own writing, my lord, on President's Rule, one of my books, you must have institutional morality. That is, if you belong to an institution or a post, the morality of that institution and its objectives must guide you. Therefore, my lord, I don't want to place it, but I'm only mentioning it. As citizens, we must have constitutional morality. But when it comes to officers and states officials, I will submit to your lordships, which is not here, they must have institutional morality also. I mean, you can't be a judge without that institutional morality. You can't be a chief secretary without, you can't be a governor. I know, my lord, your lordships have had all kinds of problems with governors, and let me leave it there, my lord. So, my lord, here once again we get a trajectory of what constitutional morality. I want to read 6.2. What is the relevant question? The relevant question is, are constitutional values undermining the Constitution also modes of limitation on the rights and powers granted by the Constitution, in addition to the limitation embedded in the Constitution in respect of fundamental rights? In other words, are we making constitutional morality a limitation? Because then everything will be affected. The next subsidiary question, which is raised directly by your lordships, the narrower question is whether such values can be read as limitations to the freedom of religious provision using the term morality in 25 and 26. And my lord, my lord, I've given stages, and I'm going very fast, my lord. One, my lord, is Johar. It treated it as a value. Puttaswamy, my lord, does not really, in the broad terms, invoke constitutional morality, but it adds it to the concept of privacy. Number 3, Joseph Shine certainly says common morality in constitutional morality and its transformation. Manoj Narula is a very important case. Mr. Dwivedi argued that if you have constitutional morality, then the Prime Minister should get rid of corrupt ministers. And that is what he should do. Now, the court replied by saying it's not a question of constitutional morality, it's a question of constitutional trust. We trust the Prime Minister to do this. So actually, Justice Deepak Mishra's, my lord, earlier view was to go into constitutional trust, not constitutional morality, as he picked up later. The next, my lord, is the NCT decision. I was fortunate enough to argue that with Mr. Subramaniam. My lord, there the question didn't arise. If any question arose, it was a question of institutional morality and federalism. Then comes Sabarimala. Sabarimala then introduces it as a limitation. And that's the real problem with the Sabarimala. If it's not a limitation, it's fine. It's the values we must all imbibe, my lord. It's a value. We can't run away from that value. It is singularly important for all of us. I'm not running away from it, neither did Baba Sahib Ambedkar. So what I'm suggesting, my lord, is we limit the question to whether it is a limitation or not. Our task becomes a little easier. Then, my lord, I come to a very important case. The entire case is in my compilation. I won't make your lordships go back to it. Anjum Kadaria, my lord, is a case decided by my lord Justice Chandrachud. It is a case concerning the validity of the Madrasa Act of Uttar Pradesh. Now, at the end of several paragraphs, this is what my Lord Justice Chandrachud says after he has invoked constitutional morality. Let me read it. It can be concluded that a statute, this is a question your lordship had put, can be struck down only for violating Part 3 or any other provision of the Constitution or for being without legislative competence. The constitutional validity of a statute cannot be challenged on the basis of violation of the basic structure. The reason of such is concepts like democracy, federalism, secularism are undefined concepts. Allowing courts to strike down legislation for the violation of such concepts will introduce an element of uncertainty in our constitutional adjudication. Recently, this court has accepted that a challenge to the constitutional validity of a statute for violating the basic structure is a technical aspect because the infraction has to be traced to the express provisions of the Constitution. Hence, in a challenge to the validity of a statute for violation of the principle of secularism, it must be shown that the statute violates exact provision. I pause here, my lord. This is the negation of the argument of constitutional morality by Justice Chandrachud himself. It is relativistic. There is no common opinion about it. Opinions differ. And therefore, if basic structure is relativistic, it must apply to constitutional morality. Now, my lord, I am using this argument of my Lord Justice Chandrachud to counter the very notion of constitutional morality because basic structure and constitutional morality are on the same footing. I won't read the conclusion. I now come to the last part, my lord.
You can substitute the words basic structure for constitution.
That's right, ma'am.
And add this.
Yes,
Same
absolutely.
passage will apply.
I'm saying substitute it because they're both relativistic, they're both undefined, and you can't use it as a limitation. Now, they used it for executive action in Bomai. I don't want to go to the older cases, my lord. I know they've been argued in case one and somebody said this and somebody said that. I want to go on the limited question, is it a limitation or not? If it is not able to be used as a limitation, then neither is constitutional morality. Now I come to the last question, my lord. My lord, because there was some talk about public interest law, and because I'm sometimes become a little brusque, I get up and start arguing when I shouldn't, my lord. And your lordship will forgive that, my lord. Her ladyship talked of the mores of the 50s being different from the mores of the 80s. Well, they're very different from the mores of the 21st century. To me, sometimes when I see certain things, my lord, I get a little brusque. Your lordship should overlook it. But let's come to that question because it's a very important question. My lord, where does locus come in your lordship's hand? It was actually in the Uttaranchal Balwant Singh case, it was examined in full. As a consequence of that, because a direction was given, your lordships, my lord, rules were changed. High courts and your lordships. Your lordships' rules are in Order 39, Rule 1230. That answers a number of questions about PIL. I'll just take your lordships to the things that I've underlined. Your lordship also has suo motu powers, but unfortunately, my lord, your lordship doesn't examine all the limitations your lordship should in a suo motu, but your lordship powers may be wider. Let's come to 12.2. B. Your facts must constitute a cause of action. Next, the nature of injury or likely to be caused or likely to be caused to the public. Your lordship will examine that. The nature and extent of the personal interest of the petitioners. Then details of the litigation. And then file an affidavit saying that there is no personal gain, private motive, or oblique road. This, my lord, is what your lordships have said about PILs. I have only, my lord, one thing that is missing from here. The derivative PIL. where somebody represents somebody else. Now, I would not like that derivative PIL to go. For the very important reason, my lord, I was discussing this with Ms. Indra Jai Singh, one of the legendary, my lord, proponents of PIL, and whom I respect greatly. A person comes to you, he has a grievance. He has no understanding of law at all. He's very rich, very well off. They've got FCRA money, but they don't understand it. So every PIL has to be translated into religious discourse. Who will do it? It is not, as the solicitor said, Bandhua Mukti. That is, my lord, of course. But an ordinary person comes to you and he says, look, this is the case. And you say to him, is it an Article 14 case? He said, I don't know. You tell me. Is it an Article 25 case? He said, I don't know. You tell me. Now, who will translate the cause of action into legal discourse? We need derivatives. And I give an example here, my lord, of the NAACP. Its legal division was separated. Thurgood Marshall, my lord, was in charge of and he became a judge of the Supreme Court, the first black judge. My lord, all that litigation concerning blacks, Brown versus Board of Education, would not have taken place but for the NAACP. Kindly bear that. We have PUCL. We have the lawyers collective that has been fighting this for 5 decades, my lord. Without that derivative PIL, we would be nowhere. And that is missing, my lord, from your lordship's rules. If your lordship is so advised, kindly have a look at it, my lord. Now, my problem with the Guruvayar decision. My lord, the Guruvayar decision was somehow, I'm going to use the word, my lord, presented to your lordships in a somewhat fuzzy way, my lord. Because it's a very expansive decision, and I'm going to quote from one part of that decision, and that will, my lord, help to understand the Guruvayar decision. What had happened in the case is that the High Court had issued suo motu notice. They had not bothered to go to the statutory authorities. They had not bothered to consult them. And so, His Lordship, my Lord Justice Sinha said, look, there are ordinary remedies. You can't just come up in a PIL. At least tell us what the rules are. Bring in the statutory authorities. And this is what Guruvayar's ratio is, in my opinion, and I will just place it. This is 7.7, page 22 at the bottom. The court should be circumspect in entertaining such public interest litigation, that is, my lord, where statutory authorities. There may be a dispute amongst the devotees as to what practices should be followed by the temple authorities. There may be a dispute as regards the rites and rituals to be performed in the temple or omission thereof. Any decision in favor of one sector of the people may hurt the sentiments of the other. The courts normally thus, at first instance, would not enter into such disputed arenas, particularly when by reason thereof, a fundamental right of a group of devotees under 25 and 6 may be infringed. Like any other wing of the state, the courts also, passing an order, should ensure that the fundamental rights of a group of citizens under 20 are not infringed. Such care and caution is required. That is the ratio of Guruvayar. Now I come to the question that your lordship actually put to me. My lord, I begin in 7.9. I don't exclude women, the locus of women, my lord. Let me say that plainly. They're partly derivative, my lord, and I don't exclude them. I say they had locus. So, in one line, what I want to say is in 7.9. The locus will lie with any aggrieved person who has a cause of action to enforce a constitutional or statutory duty. Statutory duty, my lord, suppose there is a statute under 25(2)(b, is not being enforced. Then, my lord, or avail of any right, could your lordship between any and right say constitutional? That vests in that person or group. This, my lord, in one sentence, and I'm grateful to Mr. Subramaniam, while talking here, my lord, sometimes we talked a little loudly and disturbed people, my lord, but at any rate, my lord, this formulation actually comes from our discussion. Once we are faced with an issue of threshold rejection, we have to bear this in mind. Because if you say you have no locus, it's threshold, you go out. So what is required here, my lord, is there a cause of action, constitutional or statutory duty? Therefore, my lord, once again, we are faced with an issue of a threshold rejection under 32 and 226. I come now to 7.7. It is submitted that persons of another faith do have locus in the following situations, where implementing certain universal values embedded in the Constitution, such as Article 17, 14, a classification that some other than SC/ST can enter, but not other Hindus, or under 51E and F. E and F, my lord, is very interesting because it talks of harmony, but it also talks of the degradation of women. That is why, my lord, I'm distancing myself from what the solicitor said about patriarchy. I don't want to get into all that, my lord. I just don't want to, my lord. Therefore, my lord, I say universal values are there which are embedded. Second, where a constitutional or statutory duty is not being enforced, such as enabling legislation under 25(2)(b). 3, where a religious practice affects a non-member on grounds of health, public order, morality. COVID, for example. Congregation. If morality means civilization norms, then not enforcing them as affects all. I take examples, my lord, 3 examples from COVID that Mr. Subramaniam has in his submission. I will not dilate on it, my lord, because I've given the references. Then, my lord, if your lordships will come to a very interesting case in 7.13. It was not a religious duty case. Locus will reply to any who has a cause of action to install, constitute, or any right that inheres. Now, in this particular case, my lord, a question was raised about dispute settlement, etc., of Muslims by a Hindu. Your lordship is getting a lot of petitions, my lord, of Hindus challenging Muslim rights and vice versa, etc. It's a little dangerous. Your lordship will have to do with that on a case-by-case basis. The purpose behind these is to uphold the Constitution. Now, my lord, inter se and intra-religious disputes, which is a question that was raised. I'm sorry.
With regard to this, you have added the word aggrieved person. That phrase is there.
Yes, my lord.
Therefore, can, at the instance of a non-believer, the rationality of a religious practice being gone into, whether he is an aggrieved person?
My lord, the cause of action will be the believer.
Taking it up to constitutional.
My lord, the cause of action will be in the believer. But suppose there is an Indian Lawyers Association that says that, look, we are a derivative and we are putting that claim. They will have locus.
But the believer will never question the rationality of that practice.
My lord, now I am given to understand from Ms. Jessing that she is appearing for a believer as well. That question will be decided, my lord, when Sabarimala is there.
No, because
the cause of action, my lord, of entry will always be the believer.
See, the aggrieved person cannot be on the principles of Constitution. It has to be on the question of religious practice, because you have just before done said the rationality of the practice, etc., cannot be gone into by.
Lord, I'm not on the rationality.
Actually, they are asking us.
I'm taking a simple.
Practice is contrary to the Constitution. Therefore, it is better that such a practice is given up. And if it is given up,
supposing there is a believer. Supposing there is a believer who says that this practice of yours, it may be triple talaq, my lord. It may be some practice of.
Yes.
And he says that, look, I don't think this is right. Now, in triple talaq, Justice Kurian said it was not an essential practice. The Chief Justice Kehar and Justice Nazir said it is an essential practice, therefore go to Parliament. We can't do anything about it. Therefore, my lord, believers will certainly, remember what I said about freely, my lord. A person may say that, look, this is something I disagree with. So that right, my lord, will certainly be there freely. Now, my lord, all I'm saying there. No, she wants to decide that they have no locus. So that's fine. Let her decide it, yeah. There's that much you can do.
Well, this you have put it in clause 4, where a non-member of a faith in the form of an individual or group,
Where is your lordship reading, my lord?
7.11.
Yeah, when a non-member of the faith in the form of an composed represents the cause of a member. This is the derivative PIL, my lord. Where I may be, my lord, I've represented in so many cases, my lord. I'm a Hindu who represented, my lord, the Muslims in Babri Masjid. Now the point is, of course, I started getting excreta parcels at home, and I was attacked in court, and your lordships asked me, do I need security? And I said, no, I don't need it, thank you. Now the question is, I represent them, that's derivative. My lord.
No, we are not
Now therefore, suppose,
on learned council representing.
sorry, my lord,
We are not on learned council representing.
organization.
We are on parties coming to the court, approach, knocking the doors of the.
No, my lord, the cause of action will be with the party. But I'm preserving the derivative PIL, my lord. Now, who the Indian Women Lawyers Association was, I don't know. That is a matter to be examined when your lordship is coming. Now, my lord, I come to the very important question my Lord Justice Bagchi put.
One is not.
Not on. Both on.
Yes.
My lord,
We were having a.
I can only,
Yeah, we are surprised.
We were having a small conference.
my lord, if I could lip read, my lord, and stand up like this, I would find out what your lordship said, my lord. Now I come to a question that my Lord Justice Bagchi put. What things belong to a suit? Very important question, my lord. Because my lord had then indicated that sometimes, you have to go into the evidence. And that's very important. Therefore, my lord, what I've said here on page 24, I've quoted, my lord, 3 sections of the CPC. Section 9, my lord, the history of civil litigation can be described when Section 9 was invoked. The entire history comes under Section 9. And then, of course, there's an explanation, a suit in which the right of property or to an office can mean any office, my lord, is contested in a suit of a civil nature, notwithstanding that such right may depend entirely on the decision of questions as to religious rites or ceremonies. So in a suit, my lord, certainly all this will lie. It's better examined in a suit. If you have contentions, many belong there. Constitutional duties belong somewhere else. Then I put in Order 1, Rule 8A. 8A is important, my lord, because it says that if there are substantial questions of law, other people can intervene. And then, my lord, I come to the question of 113. If in a suit you have a problem which is undecided, it goes there. So even a constitutional question can start actually, my lord, with a suit. As indeed, my lord, it did in 3 cases before your lordships. Now, my lord, this question was partly addressed by my Lord Justice Sahai in it's the famous case, my lord, the Syrian church case. Fali Nariman used to say, if you've not argued in this case, you've never been in the Supreme Court. It's the case that from 1959 just went on and on and on. But this is what Justice Sahai says, that it is only for a civil court, I cited the case, to decide rights of worship, status, office, property. Even religious questions have a material bearing on the right in question. But Justice Jeevan Reddy and Justice Sen said that this was abandoned because it was not raised before the High Court. Bear that in mind, my lord. There's a very interesting case called Shergill versus Kera before the Supreme Court of the United Kingdom. A Sikh Panth had to decide that who would have the succession to it. The lower court said we will not go into religious questions. The Supreme Court said if it affects a civil right, that is a status or property, contract, whatever, we will go into that question, even though it may trench upon religious questions. This is, my lord, what your lordship was putting very, very early on the 7th of April, and this, my lord, is an answer. My lord, I would not go through locus of persons because we have already discussed it. And The answer to your ladyship's question is 7.26. But a person of another faith cannot file a writ under 32 or 26 to raise a religious dispute that has no bearing on a constitutional right. This is page 26. My lord, I would love to read my conclusion, which is a statement of principle, but I'm not going to, my lord.
Yes, it is an association, not even a person.
Yes, my lord.
Can an
Association can have that right, my lord. But a derivative PIL, my lord, it stands on a different footing. And we should not, my lord, interfere with that right. Because it is so many people, my lord, starting with the lawyers collective, they started it in 1980, my lord. Way back. The derivative PIL. And that, my lord, should not be destroyed. Now, my lord, I won't read the conclusion because the overall conclusion, your lordships, my lord, may kindly read because it's just a statement of principles based on this. My lord, I'm very grateful and I've transgressed my time a little bit, my lord, but
No difficulty. Thank you, Mr. Dewan.
I'm very deeply obliged.
Lordship permission, may I make a small mention? Lordship, a lot is said about who filed the petition, Lord.
We will give you time, your turn will come. We hear you also.
Lordship, it's not filed by a non-believer. It has to be cleared, Lordship.
It's so late.
May it please your lordships. Lord, I begged. Sorry. Lord, I beg to appear in the first review petition as well as 901.49 by an organization, my lords, called the Ajara Samrakshana Samiti, which, my lord, if roughly translated, would mean, my lord, an association which seeks to protect the customs and beliefs. And they have also filed an independent review petition, and that is how, my lord, I beg to represent that. My lord, my written submissions are
01.49.
the first one is 901 itself.
Yes.
That's, my lord, by the Tantri, the chief priest of the Sabarimala temple. He is a party to the writ petition, R3 in the writ petition. He therefore filed, my lord, a review petition. His was the first review petition. And it is thereafter, my lords, other review petitions were also filed. And that is how the reference came about, my lord. The 901.49 is by an organization which, my lord, purports to say that it seeks to protect the customs, usages, and beliefs in the faith. That is how it has come about, my lord. But just to say that, because Mr. Vaidyanathan also, my lord, said that he was representing 4 different organizations, I just wanted to make it clear, my lord, at the outset, that these are the 2 associations, my lord, which I beg to represent. My lord, my written submissions, your lordships will get it at volume 1.1. But if your lordships are so pleased, my lord, I have hard copies of the written submissions. If your lordships feel that it is necessary.
A soft copy, what is the page number, Mr. Giri?
My lord, the soft copy, it is volume 1.1 and page 1. My lord. Volume 1.1 starting at page 1. My lord.
Page 5.
Oh, starts at page 5.
Mr. Giri.
Starts at page 5. Sorry. The PDF number is page 5.
4 is the index.
My lord, would your lordships like the hard copy? My lord, if your lordships feel it's given. Very
Yes, we will go to.
Yes. No, my lord, the first 2 or 3 pages, I'll very quickly read it only to put my submissions in perspective. I'm not inviting your lordships to get into the merits of it. But, my lord, since the whole reference is arisen, my lord, from the Sabarimala dispute as such, without inviting your lordships to get into a dispute for an adjudication on the correctness of, my lord, of the judgment as such, I just wanted to put things in perspective. I'll just read the first 3 pages, my lord, very quickly, without, my lord, making any arguments on that. Short narrative history of the Sabarimala temple and associated aspects. The Sabarimala temple dedicated to Lord Ayyappa is a temple of great antiquity, situated in the district of Pathanamthitta in Kerala. The temple stands at an elevation of approximately 1260 meters above sea level on one of the 18 mountains of the Western Ghats at a place known as Sannidhana. The temple attracts over 20 million pilgrims and devotees annually. Actually, it has gone up now. According to the beliefs associated with the temple, Lord Ayyappa at Sabarimala is worshipped in the form of a Naishtika Brahmachari, meaning an eternal celibate. The spiritual power attributed to the deity is believed to derive from this ascetic and celibate nature. Consequently, the observances connected to the pilgrimage emphasize austerity, discipline, and celibacy among devotees. The temple does not conduct daily pujas throughout the year. Instead, it opens for worship during specific occasions such as the Mandalam festival, Magaravilakku festival, Vishu, and during the first 5 days of each Malayalam month. According to the prevailing customs and beliefs associated with the temple, women between the ages of 10 and 50 are not permitted to enter the temple precincts. Birth and early life of Lord Ayyappa. The origin of Lord Ayyappa is described in the religious text as arising from the union of Lord Shiva and Lord Vishnu in the form of Mohini. The divine child was left in the forest near the river Pamba. The king of Pandalam, Rajashekara, while hunting in the forest near the banks of the Pamba river, heard the cries of a child and discovered the infant wearing a bell, which, my lord, in Malayalam is called mani, around his neck. The king took the child to the palace and raised him as his own. Because of the bell around his neck, the child came to be known as Maniganta. Maniganta grew up in the Pandalam palace and was trained in the Vedas and martial arts. His teacher eventually concluded that the boy possessed divine qualities and was not an ordinary human being. Over time, Maniganta's extraordinary deeds convinced the king and others of his divine nature. Filled with devotion, the king prayed for the Lord's blessings and sought liberation from worldly existence. In response, Lord Ayyappa instructed the king on the path of attaining moksha, salvation. These teachings are recorded in the text referred to as Bhudanada Gita. Lord Ayyappa directed the king to construct a temple north of the holy river Pampa and install his idol there. Acting on the said instructions, the king constructed the Sabarimala temple and dedicated it to Lord Ayyappa, installing the deity in the form representing eternal celibacy. The traditional priestly authority and ritual administration, I'll quickly read that. The ritual authority of the Sabarimala temple rests with the Tantri, the Vedic head priest responsible for the installation of the deity and the conduct of rituals in accordance with the Shastras. The Tantri assumes the role of a spiritual guardian and ritual authority of the temple after consecrating the idol. The office of Tantri is generally hereditary within specific priestly families. According to the traditional account recorded in religious documents, sage Parashurama is believed to have reclaimed the land of Kerala from the sea and subsequently established temples across the region. He installed idols of various deities in different geographical areas and arranged for priests to perform the rituals in those temples. 2 Brahmin brothers from Andhra Pradesh were brought to perform the temple rituals. One of them, who crossed a flooded river with the support of a leaf, after transferring the divine power to it, came to be known as Taranam, and his descendants became the Taranallur family. The other divided the river water and crossed the opening created and came to be known as Tharaman, whose descendants became the Tharaman family. The Tharaman family was entrusted with performing rituals in Shasta temples, including Sabarimala. Historical inscriptions also record that after a fire incident at Sabarimala, the member of this priestly lineage consecrated the present idol of the temple, which actually happened, my lord, in 1950. The process of pilgrimage is characterized by strict religious discipline and communal observance. Preparations begin with the Guruswami, an experienced pilgrim who has visited Sabarimala several times. The Guruswami initiates new pilgrims by placing a sacred neck chain around their necks, which they wear until they return from the pilgrimage. Before undertaking the pilgrimage, the devotees must observe 41-day Vratam, austerity. This period of spiritual discipline includes several prescribed practices, including performing morning and evening prayers before taking food or water, maintaining strict celibacy, brahmacharya, following a vegetarian diet, growing a beard, participating in daily worship and devotional singing, maintaining purity in conduct and thought, avoiding interaction with women of childbearing age. During this period, the devotees undergo a symbolic transformation. Each pilgrim is treated as a manifestation of Lord Ayyappa and is addressed as Swami. Pilgrims greet one another with the invocation, Swamiye Sharanam Ayyappa, meaning that Ayyappa is their refuge. Pilgrims usually wear black or orange garments and participate in devotional gatherings. The emphasis of the Vratam is spiritual refinement through discipline, devotion, and purification of mind, body, and mind. The rituals are intended to foster concentration, self-control, and spiritual awareness, leading towards self-realization. A pilgrimage is traditionally undertaken in groups rather than individually. Historically, the journey to the temple required traversing forests and mountains inhabited by wild animals, making solitary travel unsafe. Consequently, pilgrims travel together under the leadership of the Guruswami. This group pilgrimage emphasizes communal equality before the deity, where distinctions of caste, class, or social status are set aside. All participants are regarded as swamis. The pilgrimage traditions also reflects inclusivity, as non-Hindus are not barred from visiting the temple, and the presence of a helper deity named Vavar Swami, believed to have been Muslim, reflects this aspect of the tradition. A significant ritual element of the pilgrimage is the ascent to the 18 secret granite steps leading to the sanctum. Pilgrims may ascend these steps only after observing the 41-day Vratam and carrying the Irumudikatta, a sacred bundle of offerings placed on the head. The 18 steps symbolize the 18 Malay Devams, or traditional deities associated with the 18 hills inhabited by ancient tribal communities. Well, Lord, it'll take only 2 minutes. I'll just complete 18, 19, and 20 because it's one of the materials on the basis of which, my Lord, the denomination claimed that this practice of women between the age of 10 to 50 not being permitted to visit the temple was considered and accepted as a practice in the religion, religious practice in the religion. Deva Prashanam is a traditional ritual used in Kerala temples to determine the wishes or guidance of the presiding deity in matters relating to temple administration, ritual practices, or spiritual concerns. The ritual is performed by renowned astrologers when questions arise regarding religious practices or when the tantris themselves are unable to reach a decision on certain issues. Deva Prashanam involves astrological analysis intended to interpret the divine will and assess the spiritual condition, power, and maintenance of the temple. Within the ritual tradition of Kerala temples, Deva Prashanam is considered as an accepted and authoritative method for examining the spiritual energy of a temple and determining appropriate religious practices. Its conclusions are treated as authoritative guidance for temple worship and ritual conduct. It is a traditionally accepted astrological method adopted, especially in all temples in Kerala, to verify the particular aspect of spiritual power in a temple, its impact and maintenance. This method is accepted as an inalienable part of the science involved in the installation of the divine power in temples, its maintenance and impact. The conclusions are adopted as authoritative instructions to be followed in the system of temple worship. The philosophy involved in evolving a particular aspect of power in a temple is well reflected in the following mantra, chanted during the infusion of divine power. O the Supreme Lord, it is well known that you pervade everything and everywhere. Yet I am invoking you in this bimbam. Bimbam means, my Lord, idol, very much like a fan that gathers and activates the all-pervading air at a particular spot. As a fire latent in wood expresses itself through friction, O Lord, be especially active in this bimbam. As a result of the sacred act, it is a particular characteristic of the field of power, its maintenance, and impact which the system of Deva Prashanam divination deals with. Deva Prashanam confirms that the present practice of women of a particular age group not participating in the pilgrimage should be maintained. The Deva Prashanam confirms the disciplinary necessity, and it should be accepted as the authoritative direction from the divine power for maintaining the main objective of the pilgrimage. This is a submission, my lord, made by the chief priest, because this is what he believes in, this is what he has said. It's not a particularly, my lord, a submission, my lord, made for the purpose of this answering these questions as such. I just wanted to put it in perspective, my lord. This is one of the materials on the basis of which the collectively, the religion has always taken the stand that women between the age of 10 and 50 should not visit the temple. This is collectively, my lord, a wisdom that has been followed for years and years together, decades and decades together. Now, my lord, when your lordships come to the questions which your lordships are grappling with, my lord, I have given my submissions on issues number 1 and 2 collectively, and then, my lord, on the different submissions. My lord, the first issue is the scope and ambit of right to freedom of religion under Article 25 of the Constitution of India. And issue number 2 is interplay between the rights of persons under Article 25 of the Constitution of India and rights of religious denomination under Article 26 of the Constitution of India. Under Article 25 of the Constitution of India, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. This is expressly made subject to public order, morality, and health in the other provisions of Part 3 of the Constitution. For instance, the right under 25(1) would not allow a man to commit human sacrifice, but the said act is a crime, and it would be in contravention of public order and morality. Ban of animal sacrifices in temples by law would not be violative of Article 25(1), as such ban would only be in support of public order, morality, and health. And right under 25(1) is also subject to the other provisions of the Part 3. Thus, the individual's right to freely propagate and profess religion could be construed as subject to the right available to a religious denomination or a section thereof, inter alia, to manage its own affairs in matters of religion. Now, my lord, may I stop here for a moment, because otherwise, my lord, I'll be continuing with the reading of the other paragraphs as such. Just give me. So, Lord, please come to 25 and 26. And please permit me to read them for putting in perspective, my lord, my submissions on that. Firstly, my lord, freedom of conscience and free profession, practice, and propagation of religion. My lord, the right under 25(1) could be treated as an individual right. It is a fundamental right. What does it entail, my lord? Subject to public order, morality, and health, and to the other provisions of this part, which is last, that your lordships may permit me to come to that slightly later. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. Therefore, my lord, I belong to religion A. My lord, I have a conscience, and my lord, the conscience, freedom of conscience, need not always be, my lord, associated with a religious practice. It could be what I believe in. It's quite possible, my lord, that I am an atheist. But that's also, my lord, part of my conscience, and therefore that's part of my own, my lord, belief. I am therefore entitled to say that I don't believe in God. Suppose I also say that I don't believe in any particular religion, let alone this. I don't believe in any particular religion. That could be part of my freedom of conscience. I am entitled to assert that. But when it also, 25(1) also says, I have a right to freely profess. Profess what, my lord? Profess, practice, and propagation of religion. Lordships may deal with propagation of religion later. And lordships may also deal with free profession of the religion also, my lord, separately. Separately in the sense, my lord, because what your lordships are really grappling with is what is the right to practice the religion and what is the content of that. My lord, I believe in religion. My lord, each religion has its own sets of rules, beliefs, and probably, my lord, practice, not probably, but practices as well. My lord, Shirur Mutt says that practices of religion would also be, therefore, part of religion. Therefore, my lord, when religion A, Shirur Mutt was concerned with Hindu religion, Shirur Mutt, my lord, there goes on to say, and this is the first declaration, my lord, which I don't think should really be revisited, except for the purpose of saying that at least 2 or 3 decisions which came after Shirur Mutt struck a slightly different note on certain aspects. But otherwise, the core of what Shirur Mutt held is that the practices of a religion would also be a religious practice and would also therefore be covered by the fundamental right under 25(1), which says that I am entitled to practice my religion. One practice of religion, my lord, which I believe in is, my lord, idol worship. Therefore, my lord, I go to a temple, I am entitled to go to a public temple, and I am entitled to worship at the temple, my lord. In the manner in which, my lord, I have been enjoined to do, in the manner in which, my lord, worship in the temple is part of the faith, and it has been continued and it has been held dear to all those persons, my lord, who practice a religion. My lord, why I am saying so is because when it comes to the question of visiting the temple otherwise, and therefore, my lord, believing in idol worship, and therefore, my lord, the worshipping the deity as such, 25(2)(b), my lord, enables a state from providing for a law for not only social welfare and reform, but also throwing open the Hindu religious institutions of a public character. Please read it as temples to all classes and sections of Hindus. Now, my lord, please take it as a fact that at least in the state, my lord, from 1950 onwards, there is a temple entry proclamation, which, my lord, therefore, makes available every public temple. My lord, come to the question of denominational temple later, my lord. It is also a moot question, my lord, whether your lordship should really be called upon to decide whether a denominational temple can be a public temple or otherwise. But we are really concerned with the question of 25(1). In the context of 25(2)(b), where there is already a declaration, my lord, by the state by law, throwing open all Hindu religious institutions of a public character to all classes and sections of Hindus. And therefore, my lord, all persons are entitled to visit the temple and worship in the temple. That is what is provided for in 25(2)(b). But this is part of the right under 25(1). And therefore, my lord, what is the content of the right under 25(1)? Suppose, my lord, and this is a contention that we have taken up, my lord, but now I am not saying on merits. But suppose as part of my religious belief, or part of the religious belief, my lord, of the denomination, there is a restriction on a certain, not a class or section of Hindus, not a class or section of any religion as such. But suppose, my lord, there is an established or essential religious practice. My lord, in my respectful submission, one can't completely, my lord, jettison the principle of an essential religious practice in deciding whether the right under 25(1), my lord, takes this right or will be violated if this essential religious practice, my lord, is held here and practiced. But point is, my lord, what I respectfully submit is, my fundamental right under 25(1) is to practice the religion which I belong to, and in this case, practice the religion of Hindu, which includes, my lord, idol worship. And, my lord, when I do it, if I propose to do it, my lord, not merely because there is already a declaration by the state under 25(2)(b), but it's a temple which I am entitled to visit, then, my lord, if it is for the purpose of asserting my right under 25(1), then it cannot be in discordance with what is carried on as a practice and a belief in the temple. Not a question of public religious, not a question of public temple. But every temple, my lord, every temple has its separate characteristics because every deity has its characteristics. When idol worship is therefore an integral part of the faith of Hinduism, and idol therefore gets transformed into a deity, and the deity has a characteristic, and the deity's characteristics, maintenance of it contemplates.
So we take it, so essentiality can be gone into according to a limited extent of exercising the power under 26(2)(b). That they are some substance you are
Yes,
saying.
my lord, when I come to that, it is not my submission as a council. No, it is my submission.
We can't go into the issue whether
Correct, my lord.
it is part of the belief or not.
That's correct. That's correct.
We
That's
have to go into a little bit to that extent to test.
not this. Yes, my lord, this very fine distinction of a threshold test or test of otherwise. Well, it is a submission made, and therefore your lordships will probably deal with this. But when I say that idol worship, well, that there cannot be any dispute. That idol worship, worshipping a deity in a temple, is therefore part of the core beliefs which Hindus believe in. And therefore, my lord, then in such cases, the essential characteristics of the deity is therefore part of the worship that is conducted in the temple. My lord, I go to a temple, I don't go with a challenge. I go, my lord, for in assertion of my belief. Neither a temple nor any other place of religious worship, I don't visit there by questioning, my lord, the character of if it is in the case of Hindus, the character, my lord, of the deity there. I don't go there to question it.
No, that means what you're saying on the touchstone of the test of essential religious practice.
Yes.
You're saying the questioning of this practice by others is not correct.
Is not only not correct, according to me.
Therefore,
It
you are
is-
saying essential religious practice must be considered by the court.
If there is a dispute. If there is a dispute. In certain cases. Not under 32. But that is a different aspect, my lord. I'll come to that later. But point is this. My right under 25(1), I don't have to, my lord, lean on 14. I can't. My right under 25(1) is not in antagonism to the right or what is considered as an essential religious practice or part of, my lord, the core principles of worship, which is held by the denomination. I can't do that.
Without going into the question of essential religious practice, don't you have the protection? Why should you take the help of essential religious practice?
Not for that. I'm not saying that. I'm saying the question of deity, worship of a deity, idol worship is integral, my lord, to the faith.
Yes.
Every deity has its characteristics. When I worship the deity, I cannot do it in antagonism to the characteristics of the deity. That is not worship. That is a challenge. My right is not in antagonism to the right to the collective right or the characteristics of the deity, which is an integral part of my worship. Well, therefore, when somebody who doesn't belong to the faith wants to come to the temple, what is he coming for? Is he coming there for worship, or is she coming there for worship? Or is she coming there for questioning the faith? I'm only saying, my lord, whether she can't come to the place like a museum.
That is different. That is on the question of locus, etc.
No, not only to question it, my lord, I'm saying.
Because in the morning we heard one submission.
Yes, my lord.
Give up this concept of essential religious practice.
No.
But you are
There's a
not saying it should be there.
No, my lord, I don't think, my lord, it can be jettisoned completely. My lord, I'll elaborate on that slightly later.
And the manner you worship
Oh,
is your religious practice.
correct. But
So
we want to
when
Yes.
go
you
into
go
the
there,
essential.
go worship that religious practice. Don't go there challenge. We only attack.
Completely different argument.
I
Yes.
cannot say that they will enter, but they do in their own way, I do in my own way. It's a common set principle.
Correct.
Everybody has to adhere.
Yes.
There cannot be any segregation of and
There is
belief
no case. Sorry.
belief includes the manifestation of how it is expressed also.
Yes. But in every religion, my lord, for every religious practice, there is a manifestation. Manifestation, my lord, in this manifestation in the Hindu religion is idol worship is considered as an integral, inalienable part.
In fact, visiting a temple itself is a manifestation. Otherwise, you can
That's correct. That's correct.
at home and then
Yes.
relate to
But I don't go to the temple by questioning whether the temple has a right element of, my lord, divinity in that. I don't go for that. I go there for worship.
So in Sabarimala, what happened? The majority said that this non-permission for between 10 to 50, that is not an essential religious practice.
You don't have to get into that. my lord.
Therefore, we are asking you,
yes.
what's your nuance on that?
Nuance on that is this.
Suppose the court thinks that a particular practice is not an essential religious practice.
No, they can't get into the question. No, my lord, it is not possible for the court to get into whether it's an essential religious practice. That's, my lord, my first submission. This is a faith. There is no question of, my lord, looking at the logic in faith and trying to import Article 14 in that. That is not it. Right, content to the right under 25(1) is a right to worship. And when I exercise my right to worship, I believe in that place. I believe in the temple. Part of a character of the temple is where the deity is a Naistic Brahmachari.
We understand the argument. According to you,
Yes.
it is not the practice by such. It's more of a belief.
Correct, my lord, it's a belief.
Belief is attached to the temple,
Yes,
attached
yes.
to the deity, attached to that.
Yes,
Therefore, to the extent that you cannot get it.
that's correct, my lord.
Whether if you have a belief, you do it. If you don't have a belief, you can't go there to question.
Go there.
Cannot be any attack on
If you
that.
don't have a belief, go there.
That's it.
I don't believe in that place.
Okay.
I don't go there. I don't go to that place as a museum. I go there as a place of worship. And if I have to go there as a place of worship, it is my belief. I have to believe in that place. I have to believe in the deity. If I believe in the deity has certain characteristics. If the deity,
Those who are believers, women who are believers between the age of 10 and 50,
yes,
have to restrain themselves from going to the temple.
because it's part of the belief.
So that is questioned by persons who are in association.
Have no business. Have no business. They have no business. I am dealing with a very sacred right of mine under 25(1). I don't want somebody else to come and question. On my behalf, no. Look, with due respect to Dr. Devan, derivative PL, what derivative PL? If I want to assert my fundamental right under 25(1), I do it. My lord, in a remote way, probably I can think of some woman, my lord, saying that, no, I have a right to go there. Then you have to question. If you want to do that, you may have to question it. But there is no face-off, my lord, between a person who asserts a right under 25(1) and the denomination's faith.
Just a minute.
Absorb.
Ten 10:30.
Very good.
Yeah, 3:35 हो गया.